Okay, good morning everybody. Welcome to the Professional Symposium, Attorney Professionalism in the Commonwealth of the Northern Mariana Islands. My name is Justice John A. Beloya, for those of you who don't know me. I am from the Commonwealth Supreme Court. And by the way, this symposium is being televised. No, it's being recorded for future young attorneys so that we don't have to do the symposium every 6 months or every year. Anyway, this CLE is sponsored by the CNMI Bar Association. Thank you to the Bar President, Lydia Tenorio, and the Commonwealth Supreme Court, as well as the U.S. District Court for the Northern Mariana Islands. And this is required by Section 3C of the Commonwealth Rules for Continuing Legal Education. Last year, we invited Ninth Circuit Court Judge Margaret McKeon to give a presentation on professionalism. We are thankful to the District Court, Chief Judge Ramona Mangloya is here, for providing the financial means to make that presentation possible. And then just a few months ago, Ned Brassington asked us to sponsor another professionalism CLE because, from what I understand, some of you didn't want to spend your Saturday in last year's conference. Or maybe it might be the case that we really need a refresher of professionalism here in this jurisdiction. So here we go again, another round of professionalism. Now, ethics and professionalism are similar but not the same. If ethics represents the floor of attorney conduct, then professionalism is akin to the ceiling. In other words, professionalism encompasses more than ethical behavior. It includes the responsibilities one has not only to the clients, but to the legal system, to the institutions, and to society at large. Professionalism is an attitude and approach to our occupation as attorneys and judges, and its elements include scholarship, integrity, honor, leadership, collegiality, and just common sense respect. And the perception of lawyers' lack of professionalism is real. In 2015, for instance, a Gallup poll found that only 21% of those surveyed rated the honesty and ethical standards of lawyers as high or very high. That's 21%, and you will see the survey later on. These ratings, of course, are substantially lower than the ratings for doctors, pharmacists, high school teachers, and even, I think, real estate agents were ranked right along with them. And then last decade, in 2002, the ABA section of litigation did a survey which resulted in 69% of those agreed that lawyers are more interested in making money rather than serving their clients, and less than 20% felt that the terms caring and compassionate described lawyers. So 20%, that's quite low again. But that's a 2002 survey. I hope it has improved to maybe 25 or 30%. Whether these perceptions are reality is an issue attorneys and we members of the bench must reflect upon. So today, the symposium presents an opportunity to assess the practice of law and to consider the oath to serve the Northern Marianas as true legal professionals. And we have a panel, the first panel of guest speakers will focus on professionalism before the court, the views of justices and judges. We are honored to have these speakers today, and I will call their names now. This first panel will be moderated by Michael Ernest. Mr. Ernest, please come up here. And we have Chief Judge Ramona V. Mangloya from the U.S. District Court for the Northern Marianas. We have Associate Justice Perry B. Enos. Initially, we were supposed to have Chief Justice Alexander Castor here, but he's down with a cold for the past 3 days. So, Justice Enos. We have Magistrate Judge Heather Kennedy and Associate Judge David Weissman.
Right here.
So, thank you, Judge, for being professional. You're prompt. The second panel will be comprised of local attorneys, and they will focus on the topic of professionalism between attorneys, the importance of civility, courtesy, and respect. This panel will be moderated by Assistant Attorney General Barbara P. Cepeda. So the background of our distinguished guest will be detailed later. So that panel, anyway, will be comprised of attorneys Rex Kosek, Catherine Cacharo, Timothy Bellis, and Jennifer Doctor. I think I saw Jennifer here today. Yes, she's back there. So I think it's an exciting agenda this morning. I thank the bar for coming out with this symposium. And thank you all for your participation, also in advance to all our distinguished speakers. Mr. Ernest.
Thank you, Justice. Can you all hear me without the microphone? Yeah. So good morning, everyone. My name is Mike Ernest. I'm Assistant Attorney General. I've been asked to help moderate today's panel, and I'm very honored to do so. Before we begin, a quick introduction of the panelists. To my immediate side is Chief Judge Ramona B. Manglonia. She currently serves as the first female federal judge of the United States District Court for the Commonwealth. President Obama nominated Chief Judge Manglonia in January 2011, and the Senate confirmed her nomination in July of that year. Chief Judge Manglonia graduated from the University of California at Berkeley and obtained her JD degree from the University of New Mexico School of Law in 1996. She's admitted to practice in the state of New Mexico and the Commonwealth since 1997. After law school, Chief Judge Manglonia served as law clerk at the CNMI Superior Court. In 1998, she joined the Criminal Division of the Attorney General's Office as a prosecutor. After 3 years with the Criminal Division, Chief Judge Manglonia worked at the Civil Division as a litigator. In 2002, she became the first female Attorney General for the Commonwealth. The following year, Chief Judge Manglonia was appointed to the Superior Court as an associate judge, where she served as the only female judge for 8 years. She also served as a pro temp judge and justice on the Guam Superior Court and the Guam Supreme Court. Chief Judge Manglonia was active with the CNMI Bar Association, serving as its president from 2001 through 2003. She was also active in the formative stage of the Joe Tenkizu Public Library. In recent years, she's been active in the We the People program, National Forensics League, and high school mock trial competitions, serving as a coach, advisor, and/or judge. Please welcome Chief Judge Ramona B. Manglonia. Next, I have the honor of introducing Magistrate Judge Heather Kennedy. Heather L. Kennedy is the Clerk of Court and part-time Magistrate Judge for the U.S. District Court for the Northern Mariana Islands. Magistrate Judge Kennedy started as Clerk of Court on April 15, 2013, and assumed Magistrate Judge responsibilities on June 11, 2013. She is one of 3 to occupy this combined position in the federal judiciary. Before joining the District Court, Kennedy was Executive Director of the Law Revision Commission, so she's pretty familiar with these areas, I imagine, and General Counsel for the Commonwealth Judiciary, as well as the Mock Trial Coordinator for the NMI Bar Association. From 1999 to 2007, Kennedy worked as legal counsel and equal opportunity officer for the public school system until joining the Commonwealth Judiciary. Before moving to the Commonwealth in 1999, Magistrate Judge Kennedy worked as litigation associate for a corporate law firm in St. Louis, Missouri, and as an assistant public defender in Charlotte, North Carolina. She was born in New York and raised in Connecticut. She graduated from Guilford College in Greensboro, North Carolina, and earned her JD from Washington University School of Law in St. Louis, Missouri. Please welcome Magistrate Judge Heather L. Kennedy. Next, I have the honor of introducing Associate Justice Perry B. Enos. Justice Perry Enos was born on Saipan on September 26, 1966. He ascended to the bench as an associate judge on September 22, 2008. He became an associate justice on March 8, 2013, after the Senate confirmed his nomination and he took the oath of office as an associate justice. Justice Enos graduated as a proud graduate of Rhoda High School in 1983. He received his BBA degree in business management from the University of Guam in 1987. He obtained his JD from the University of New Mexico Law School in 1994. He was in private practice before his appointment to the bench. Prior to his law career, he was a teacher at Rhoda High School and a student coordinator at Northern Marianas College. Justice Enos is married to Deborah Enos, and they have 3 children. Please welcome Associate Justice Perry B. Enos. Finally, I have the honor of introducing the Honorable David Arthur Wiseman. Judge Wiseman was appointed to serve on the Superior Court bench as an associate judge in 2001 by then-Governor Pedro P. Tenorio. In addition, Judge Wiseman has served the Commonwealth as a special judge for 5 years and associate judge for over 15 years. Judge Wiseman has also served as a designated judge for the United States District Court for the Northern Mariana Islands since 2001, consecutively through the present time, by annual appointment by the Chief Judge of the United States Court of Appeals for the Ninth Circuit. Judge Wiseman has also served as a Justice Pro Tem in several cases before the Commonwealth Supreme Court. In addition, Judge Wiseman has served as a designated judge for the Supreme Court of Guam and the Superior Court of Guam. Judge Wiseman first arrived in the Commonwealth on July 7th, 1977. That's 7/7/77. During the transition period of the former Trust Territory District of the Northern Mariana Islands into the Commonwealth government that it is today. Judge Wiseman and his wife, Faith, were field enrolled into the Peace Corps and assigned to the pre-Commonwealth Mayor and Municipal Council for Rhoda. Judge Wiseman has served as legislative counsel in various capacities to the 1st, 2nd, 3rd, 5th, and 11th Northern Marianas Commonwealth legislatures. He has also served as counsel to a number of government agencies and was also a practicing attorney for 19 years before ascending to the bench. In addition to this wealth of legal experience, Judge Wiseman has also served as an important research to the Commonwealth community at large. Judge Wiseman was the co-founder of the Hotel Association of the Northern Mariana Islands, it's HANMI. Judge Wiseman has served on the board of directors to the Saipan Chamber of Commerce and continues to serve as an honorary member of the Chamber. He has also served as a chairman of the Armed Forces Committee of the Chamber of Commerce. Judge Wiseman is also a former chairman and present member of the Friends of Saipan Beach Pathway. Also, he's a present member of the Saipan Economic Development Council, or SEDC. Unfortunately, Judge Wiseman will be retiring from the bench during the latter part of May. Judge Wiseman's long commitment to public service in the Commonwealth has earned him the respect and admiration of the Commonwealth community and government. There is no person more qualified to provide insight on professionalism in the practice of law. I'm happy to welcome Judge Wiseman to today's panel to share his perspective on the topic with the members of the audience today. And I would ask that you join me in welcoming David Arthur Wiseman. Would you get the next slide, please? Before we begin, because there are a Justice of the Supreme Court and the Chief Judge of the District Court who are policymakers, I have to say that nothing you see or hear today will supersede or amend the disciplinary rules established by the Supreme Court or the District Court. Nothing establishes a standard of conduct against which lawyer negligence might be judged or becomes a basis for the imposition of civil liability of any kind. Nothing establishes a new basis for any form of disciplinary proceedings or enforcement, or establishes any Commonwealth Bar or Office of the Attorney General policy or set of principles. Standard CLE disclaimer, you're all here to learn, and this doesn't change any of the rules. And I suppose I have to give the disclaimer that keeps me employed. Nothing I say or none of my opinions reflect on Attorney General Matabusan, Deputy Tenorio, or the Office of the Attorney General. Basically disregard everything you hear me say. So we can get started. I know it seems sort of counterintuitive to invite this wealth of judicial knowledge here and then let them sit for a minute, but that's what we're going to do. They get an hour and a half to talk to you, but I'm going to take the first 2 minutes and ask you guys, what does professionalism mean to you? So as a practicing attorney in the Commonwealth, when we say we're going to do a CLE on professionalism, what are we talking about? What do you think we're talking about? What does professionalism as an attorney mean to you?
Do we have the right slide?
I think that's the right slide. So seeing no volunteers, Chuck.
What is professionalism? To me, professionalism is a combination of skill, respect, integrity, honesty. In other words, Mike Ernest.
Anyone else? So basically, they're blank canvases, so you have your work cut out for you. If I get the next slide, please. The second question, and then we'll jump to the panel, is how would you, as practicing lawyers in the Commonwealth, characterize the professionalism of the lawyers in our bar? Do we think that improvement is needed? In other words, how's the water out there? You're swimming out there, what's the legal profession like? Are we professional? Are we not? Is today a waste of time?
Too early, Mike?
I don't know.
Yeah, so Patty, can I get a show of hands of how many attorneys here have been practicing law for, say, less than 3 years? 1, 2, 3, 4, 5, 6. What about less than, say, 5 years? I mean, can you, with the 3? Just to see how, so 5, let's go 10. Oh, that's almost more than half, huh? Maybe flip it then.
Inside that?
How many attorneys?
Marianas?
No, just practicing law. Over 10 years. Wow. So we've got the whole spectrum here. Maybe that's why they're kind of shy, Mike.
Right. Josh Berger, you're a longtime practitioner.
Too long.
How are we doing now? Has it gotten better? Has it gotten worse?
I've been practicing over 35 years.
Josh, can I ask you to stand up, please? I know we're not in court, but I just want to make sure everybody hears and
I've been
sees.
practicing over 35 years now. I've been here since '93. I think it's improved, but I definitely think there's need for improvement. I think sometimes attorneys, and I'm an old attorney, so the younger attorneys and middle-aged attorneys are too much in the battle and not looking at the profession as not just a profession. It's not a win-or-lose situation. You have to treat it honorably, integrity, and fairly. And that's what I've seen. I think as you get older, you tend to mellow out. I think when you're younger, you tend to think of it more as combat or battle. I see that problem, especially with the younger attorneys.
Can I pick on Dave Lockerbie? I think you also have that senior status. Would you like to add to that, or?
I have double senior status.
You have double senior status.
I reached both ends.
Okay.
Yes, thank you.
Tell the young ones how long you've been practicing law.
I've been practicing law since 1978.
Many were not even born.
But most were not even born. I predate, as a matter of fact, most of the population of the earth. And I agree with Mr. Berger. I think things have improved since I've been here, and I came here in 1998. Although the litigation atmosphere, I think, is quite different. There seems to me like there's a lot more litigation than there was back then, even though there were more people here back then. The litigation environment, I think, is different. I think we're on the right path. I've practiced in 2 other jurisdictions, and I think we compare favorably.
Why do you think that's the case now that the older practicing attorneys are more civil than the younger practicing ones?
Well, I think that depends on the individual. I think that an argument can be made that the younger professionals, who are still professionals, the younger professionals, take a more, I don't want to say active, take a more, are out to not to prove something, but young people and young animals and young dogs. We're all the same. Have more energy. I think in ways they actually work harder because you know less, so you have to research more, so you have to dig into things that older lawyers perhaps wouldn't do. I know that when I look at things now, I'm generally looking at something I've done before, and that's not true for younger lawyers. And when you're young, I think in many ways the profession is more interesting because you're always learning new things. I know that when I was very young, I used to go to a certain bar on Sunday afternoons. I would just sit there by myself and have a couple of drinks, and I would just have these legal thoughts rumbling around. I used to call it the attic of my mind, and it was quite interesting. It's only rarely now that I do that. But the law is so beautiful in so many ways. But if we use it as we use it all the time, it kind of dulls. So I envy the young lawyers who are having that awakening. I hope they are.
Mr. Presley, you're a younger lawyer than Mr. Locke. Do you agree with this opinion or statements?
I think where he was initially going with that, I see younger lawyers trying to prove themselves, and so you can lose the forest for the trees, so to speak, where you can be overly aggressive to try to win, and I think I agree with Mr. Berger too that some of the older attorneys do tend to mellow out a little bit, and so yes.
Thank you.
We'll get that next slide, please. So two attorneys said that they saw it getting better. This chart actually goes from right to left. From 2000 to 2015, the public was asked how they rated the ethical standards of lawyers. The orange is bad and the blue is good. So right now, the latest one, 2015, fewer than 25% would rate attorneys as high to very high ethical standards, and over 35% rated as low to very low. So it's better than it was 15 years ago, but we still are net negative of 15%. And again, that 35% isn't, oh, you guys are okay. It's we are low to very low ethical standards. And so that's how the public sees us. And so can we get the next slide real quick? Justice Mangalonia referred to this slide when he was doing the introduction. We are ranked right above real estate agents. We are 3 times as trustworthy as car salespeople, but nowhere near as trustworthy as a nurse. So that's where we are. Yeah, we beat out lobbyists. Lobbyists are the absolute worst. So that's the state of the water. That's what we're swimming in. No one really, very few people think that we're ethical. We really can't control people's perceptions of us. We can only control our actions. And I think that's kind of the focus of today's panel and what professionalism is all about. Can we get the next slide, please? So we're going to start at the beginning. I know this seems very, very easy, and it almost seems not worth a panel of this magnitude's time, but I was a clerk for the Supreme Court, and I can tell you I'm very familiar with the members of the judiciary, and this question does rub judges the wrong way. So as my service to all of you, I would just like to ask the panel, let's start with Judge Wiseman, what is the proper way to address the court?
Yeah. A judge in court, when addressed as a judge, is the epitome of impropriety. It's always your honor. There has to be honorifics in court. It all ties into the bigger picture of the public having confidence in the integrity of court. And that depends on the professionalism of the attorneys, not only in court, but in practicing as an attorney, but also out in society. And in court, a judge is the honorifics. A question is never to be answered yeah, yes, no. It's always no, Your Honor, yes, Your Honor. An attorney should always stand up when addressing the court. Your Honor is not appropriate outside of court, although that's very common. I mean, we all walk around and people come, oh, hi, Your Honor, hi, Your Honor. Your Honor is really reserved for the court. Our Chief Justice one time, several years ago, gave a very detailed definition of Your Honor and judge and so on. So that's it. But and you know, body language also is very important in addressing the court. In addition to the yes, Your Honor, I mean, there's certain body language that is consistent with respect. And it all has to be respect in the court. Without respect, I mean, our robes and everything else really don't mean much. There has to be a whole system of professionalism. And you know, there's a preamble to the new disciplinary rules that were recently adopted, and which I worked on for some part. And that preamble says when you have the privilege of being licensed to practice law by the Supreme Court, that incorporates and implies a whole commitment to that sense of a common mission to promote that the public's confidence in the integrity of the court by being professional. And professionalism goes beyond ethics. And let's remember that the legal profession, unlike the majority of other professions, is not a profession where the lay person can see if we're doing right or wrong things in court. We are self-governed. So, I mean, if a lawyer violates the rules, disciplinary rules, or any ethical code, it's not the public who says, hey, he's doing something wrong. They don't know. Someone brings a case for malpractice, you need an expert witness. You can't have lay people deciding the standards. So we're self-governing, and with that comes an obligation of each attorney to just have that common sense, that sense of mission of professionalism in courts.
So, Judge Kennedy, you're a magistrate judge, and are the rules the same for you, or are they different? And does it matter to you?
It doesn't matter to me. You know, I've been called magistrate, and that doesn't essentially matter to me, but according to the rules of how to address magistrate judges, and I'd gone to my first magistrate judge training, and they actually did a buzzer every time we referred to ourselves as magistrate. It's supposed to be magistrate judge. That's the complete title, and the argument was you don't call district judge district, you don't call bankruptcy judge bankruptcy, so you don't call magistrate judge magistrate. And that would be the proper way to handle it. And I know that I have the unique position of dealing with people when I'm not wearing my magistrate judge hat, when I am the clerk of court. So I don't hold it against people when we're in that context and they call me Heather or they address me as Miss Kennedy, because that's proper in that arena. But when I am sitting on the bench or handling a settlement conference, it's pretty clear what my role is, and then it's Your Honor or Judge.
Chief Judge Mangoldia, anything to add?
I agree with what Judge Wiseman just stated. In the courtroom, we do have the distinction of recognizing that we've got different powers at play. You know, as attorneys, if you're the prosecutor, you are not the individual. You are representing the state or the CNMI. So likewise, when a judge ascends on the bench and the proceeding begins, I would expect that recognition only to ensure that everyone else basically appreciates the whole process and the dignity of the process. But personally, off the bench, I don't expect to be called Your Honor. I actually kind of feel uncomfortable. But judge is fine with me, and for those that are very close to me, one is fine.
Justice?
Outside of the courtroom, they're saying about courtroom addressing the court or the judge in court. But let me just tell you some of the names that we've been called from either parties, non-represented litigants. In the Supreme Court, we've been addressed as, well, you guys know. So we've been called guys. You know what the response is to this. In one of my adoption proceedings, at the trial court level, a pro se, an elderly lady, a pro se adopting parent asked for an adoption to be granted, and after I did grant the proceedings and everything, she goes, "Thank you, boy." We've been called boy and you.
I'm assuming that's frowned upon. Next question, please.
Tell you what, the whole audience were just laughing.
Question 2, courtroom attire. I have to admit, Judge Wiseman has threatened to send me back into his chambers to wear his ugly tie when I have been called into court on an emergency basis and didn't have a tie.
Yeah, that stems from some history here. Back in the 70s, I think maybe 2 or 3 would know this, maybe here. There was a lawyer here by the name of Ben Abrams, and this was during trust territory time, and there was no dress code. And he would walk in, and Judge Hefner, who was the Commonwealth first presiding judge, Chief Justice, he was in the trust territory court. And Ben Abrams would walk in, and there was no dress code, but he was too much. I mean, a wrinkled, filthy T-shirt with zorries and shorts with holes in it, and and until finally Judge Hefner said, "That's it. We're putting a dress code in." And he had a dress code, and he would keep the most raunchy, oldest ties you would ever think of in his office. And to get everyone used to wearing a tie, he would take them in. And he would sort the tie. And he had to wear a tie. And then it became, the dress code became more formalized. And overall, I don't have any problem. I think all the attorneys, with the very rare exceptions, some emergency or something, come to court properly dressed. So that's a history of our dress code.
So, Chief Judge Mendolina, do you notice a problem with practitioners in your court being poorly dressed? Or is this a Commonwealth Superior Court issue?
Well, I didn't have the experience of having someone so dressed down as such, but in our district court rules, we do have a mandate that the men wear the tie, and women also are restricted from wearing anything overly revealing. And these rules are strictly enforced by our marshals. I've been called upon to say, can we let this person in? Because they have been provided. One actually was a witness who refused to put on any shoes. I think some of you may know that person. Walks around without shoes. And I said, he's got to put on shoes. And so they had to bring the medical slip to me to show that putting on the shoes was actually going to hinder his health. And that was the extent. And we also have it in our jury plan. So jurors are advised, especially in our cold courtroom. Some of them show up in shorts. I did not see, because once I get on the bench, the jurors are already in the box. I didn't see one was wearing shorts, and then they're already shaking. It's like, well, why didn't they comply with the rules? Sometimes it's for their benefit. I did have an attorney show up without the tie, and I said, counsel, I'm not going to recognize you. You need to step out and comply with the rules. Fortunately for my courtroom, the audio system is broadcast even to the clerk's office, and I just had one of my clerk staff was so kind, because within less than a minute he was back in finishing up the tie, and everybody started chuckling, thinking which of the CSOs got stripped of that tie to get him to continue. It goes to the first part about, again, recognizing this is a formal proceeding. I've had a visiting federal judge from off island come to me and say, do you actually allow the lawyers to show up without a coat on? because different rules in different districts. And I said, well, if it's a motions hearing, I don't have a problem with the tie only. It's hot here. But if there's a jury trial, I expect every counsel to be in a formal suit, men or women.
And I would just add to that, it's a very good idea when there's a visiting judge in our court to find out what they want. Because when I tried a case in that court, I ended up not in front of Judge Munson. I ended up in front of a very strict judge out of LA, who I remember scolding someone in the audience for having their sunglasses on the top of their head. And I had to rummage through and borrow clothes to make sure I had a jacket for the long trial that we had. So it's a good idea, and you can just call our clerk's office and they'll give you the idea of what this judge is like as far as their expectations in court.
So the next 3 slides actually show General Order 2000-100. Appropriate attire is suit and tie, a woman's pantsuit or dress suit, dress pants and dress shirt with tie or blouse with blazer or jacket, dress with blazer or jacket, skirt and blouse with blazer or jacket, dress shoes, women's pumps. You can actually read this, and the judges have never read this way, but this actually requires men to wear either a suit or a blazer. This, by one reading of this order, it would not even be acceptable. I can say that I never really very often did wear a jacket in the Superior Court. The next slide talks about prohibited attire. No zoris, halter tops, midriffs, tennis shoes, island shirts. And the next slide is the federal local rule, which is more permissive than the Commonwealth rule. It just talks about a dress shirt and a tie. Dress shirt, necktie, dress slacks, socks, and shoes. Apparently, Chief Judge Mangaloni requires a suit for argument and during trials as well. And again, the last sentence, the court may refuse to hear attorneys whose appearance does not conform to this rule. So I would imagine they do take that quite seriously.
Before you move on to the next one, can you say something?
Of course.
We are actually floating the idea of having half-a-day Fridays, which is basically your best Sunday wear on Fridays, maybe dispensing with the tie. And I'm also throwing out the idea of having the New Mexico type of bolo tie, the Southwestern type, be allowable on Fridays. And the Carolinian beads and the Chamorro Sinai, those are like ceremonial accessories, I guess. So we are floating the idea, so might be before the end of the year you'll see some changes in this area.
Yeah, do you have a question?
Yes, a question. I've always wondered, what's the female version of the local, the customary dress? I know I'm asking male, but I'm sorry.
The local even.
For instance, when the males are able to wear the island shirts, what's the female version of that?
You got me there, I don't know.
I would think, if someone may correct me, I would think that would be okay if you had a nice top, but it was short sleeves instead of having long sleeves. I would think of that. Dresses and less casual shoes, but not flip-flops. That's the way I think.
I guess I'll respond to that question. I've been to the Guam District Court on Fridays, and it just shocks me when I take the bench and I see the lawyers in there with floral prints, and I thought, wow, you guys are lucky. So it's been adopted elsewhere. But for the women, I guess what I've seen is more of the floral dresses, and some just because of the practicality as well. Still, Magistrate Judge Kennedy mentioned the short sleeve, but if you're going to be in the courtroom, it's going to get cold. So maybe a little small sweater or something of that nature.
Do you need a long sleeve voice or one lawyer short sleeve? The rule just says shirt with tie. I would imagine any button down. But ultimately, it's the judge's courtroom, so anything I say isn't going to... Whatever you feel comfortable wearing in front of the judge when he or she is on the bench is all I can say.
John's Burger likes coming in with short shirts and tie, it's okay.
Yeah, I'm still confused. It seems like each court has a different.
It doesn't have to be a long sleeve.
You're okay without a sport coat except for trial?
Yes.
Supreme Court, I think you always want a sport coat when you argue.
Oh, yeah. Supreme Court's different.
And then the trial judge, you don't seem to care as long as you have a certain time, like red short sleeve or long sleeve.
Well, for me, I mean, the more formal or proper dress, for me, it adds to the overall respect in the court. And again, I reiterate that public's confidence in the integrity of the court, public's confidence is very important. So the better the dress, I don't require that, and it doesn't affect me one way or the other, except the overall mission that professionalism should mandate is to keep that public's confidence going as much as possible in every little aspect, including formal dress. Adds to that. That's just my opinion, but it's not policy.
So we'll skip to question number 5. Excuse me, back to question number 4. Is it more appropriate to state that an opposing party is misrepresenting or misapprehending the law? And this is to anyone. And I think you can all see where we're going with this question.
Well, it really depends, right? If you want to call a lawyer lying, then I guess misrepresenting. But if you want to just focus on the subject itself, I would choose misapprehending to just try to say that the lawyer maybe needs additional 5 minutes to read the law to, I guess that's the worst way to say misapprehend. To spend more time reading what it means, rather than judge he's lying to you.
Yeah, the name calling is not going to carry the day. That actually runs very bad against me. I mean, it's not going to, the one calling another party that, to me, it's almost like you're grasping for straws. Well, you know, I win because he's lying. It's look at what the law says and argue your case, because there are differences of opinions. I mean, Brown v. Board of Education came about because there was a difference of opinion. But at a certain point, there's some things that we just say, well, we've got precedent, and in this arena, actually, in the Commonwealth, that's one of the wonderful things I think about practicing law here is there's a lot of new law to be set. And that's where I do encourage some novel arguments, but to say that, well, that's a misrepresentation of the law, that's very bold. You better be very clear and ready to back that up, because otherwise you are going to be expected to apologize, and if it's not, that's might even be sanctionable, and furthermore, disciplinary. So be very careful, and if you cast that one rock, people may be ready to cast it back at you.
I'd just like to comment on the Brown versus Board of Education. That's a major national decision, 14 pages. You can't find a decision with less than 50 or 60 pages from the U.S. Supreme Court these days. 14 pages. 1956.
I have a question. Would it be sort of a middle of the road to focus on just the statements that have been made about the law? So if you said he's misstated the law in this way, and would that contribute to more of a push and pull sort of negotiation on the meaning of the law, or would that also be seen as disrespectful?
What I heard is a misstatement of the law, meaning you can go, say, back to the actual case law or the plain text of the statute, for example. That would be appropriate if you've got something that's black and white, and then let the tribunal make the final decision. But this misrepresenting seems to be more of an attack on the individual, and that is not permissible.
So for the next question, I always wondered this. I clerked for a trial court judge in law school, and the only answer he would give me was, Michael, there's life after reversal. But I was hoping for the trial court judges, do you follow, clearly you read the mandate, you read the case, but how tough is it when you get overturned on appeal? Does it ruin your day? Does it slant? Does it slant the rest of how you? Because there's a mandate, and then you're still the judge for the rest of the case.
What do you say? We disagree.
Well, I follow appeals decisions in not only this court, other court. pretty regularly. And when I get a reversal, which is not that common, but sometimes, I look at it, I recall Thomas Edison, the inventor, and he was interviewed and he said, they asked him, well, how does it feel to have failed thousands of times in inventing a battery? And he said, oh, I didn't fail, I just learned that many ways not to do it. So, I take that as a learning experience. I don't add those decisions to my decisions in the Supreme Court. They don't affect me much.
Associate Justice, on briefs to the Supreme Court, how should appellate attorneys refer to the trial court rulings, holdings, decisions? How should they refer to the litigants? Should they call them defendant or appellant? Should they name them?
First, as to the first part of the question, I think that the attorney should refer to the trial judge's ruling. Track the standard of review. If you think that the standard of review is abuse of discretion, just say that the court abuses discretion, or the court plainly erred, or the court erred. Another standard of review statement is clear error. The court committed clear error, rather than the judge didn't weigh the evidence that we submitted correctly. Those are a little bit harsher words, but try to track the standard of review statement.
Is it the same? I'm not quite sure how it works when someone disagrees with something the magistrate judge says. Are you treated sort of like a quasi-appellate court then, or?
Yeah, since this is a new era of having a magistrate judge within our district, we do have the reports and recommendations. I think some of the practitioners that also practice in Guam would be familiar with that. So, as a magistrate judge, Judge Kennedy does have jurisdiction to make preliminary rulings. Not only have her handle all the settlement conferences, that's something that's a big change. But when there's a recommendation for any substantive decision, both in a criminal arena, she could actually accept a change of plea and make that recommendation to the district judge, myself. And so those are things that we can do. And in the civil matters, I haven't had the opportunity to do it in any of the cases here, but that she's already had 2 cases go with another district judge. 2 or 3. And I've handled some of the cases out of Guam for reports and recommendation, and I do sit as an appellate judge in that fashion. Then, of course, the final continues on to the Ninth Circuit. And by the way, regarding the appeals as a trial judge, it depends on how you view it. Some people, one comment made by another federal judge is that when an appeal is taken from our court and goes to the Ninth Circuit and gets affirmed, the sentiment is, well, I still got it right. Because the thought is, well, if we went further up to the Supreme, because of the statistics that the Ninth Circuit gets reversed too often, then it's wrong. But I think we strive to do our best to make the decision correctly. The first time I think many lawyers have heard me say this many times is in handling or presiding over cases, I want to do this once. I don't want to do this again. So let's take care of it here, and then when you go up on appeal and exercise that right, then let the next panel of 3 or even the en banc, that's a matter of numbers, and then if you're lucky to go all the way up to the Supreme Court with 9.
And I just wanted to add to on the magistrate judge part, it all depends on the posture of the case. I don't talk loud enough. It all depends on the posture of the case. If I have what's called a consent case, if the attorneys consent to me handling it, will go to the Ninth Circuit. It won't go to one of the district judges. If I handle a detention hearing, for example, and that wants to be appealed, that can be appealed. Essentially, you file what's called objections within 14 days, and that's the process. So it depends on how I'm handling it. And then there's this third requirement that Judge Mangloni was talking about. Certain things I may do what's called a report and recommendation, and then there's a process for the parties filing objections to that before Judge Mangloni would make a final decision, or a visiting district judge may make a final decision.
Judge Weissman once whispered to me in a social setting that he was right, we just disagreed.
And usually in most courts, not only here, but most trial courts, decisions, they're usually right for at least a year.
Moving on to question number 6, I believe Justice Mangalona answered this in his introduction, but does professionalism extend beyond ethics? So in other words, do they cover the same ground, or are the rules of ethics the floor and professionalism is something more aspirational, or is acting professional actually the floor? Is it a floor and a ceiling?
Well, in my point of view, I think everybody here took an ethics class, right? Law school, the MPRE. That's the basic, that's the floor. But because of how the practice of law has evolved and some of the problems that have arisen, I think that these professionalism standards have been adopted to supplement. And in the district court, I think the pink flyers were distributed, we do have the standards of professional conduct. And as you can see, these standards are incorporated and go beyond the model rules of professional conduct. This is really highlighting all the concepts to ensure that when we engage, when attorneys engage a client, when the attorneys appear before the court, we have these additional responsibilities to be observed. Because I say duties, and I think everybody's always saying, well, I don't have a duty to do that, or the rules don't tell me to do that. And I said, but simple courtesy, professionalism. And I always make the comment that we are a very small district, a small legal community. I even recognize it all the time when I speak to my colleague in Guam that their bar is much bigger than ours. And so we have a lot of solo practitioners, a very mixed composition of young attorneys and older attorneys. So it's really something that does need to be harnessed in regards to what's the minimum to comply. And I would like to highlight as well Rule 1 of the Federal Rules of Civil Procedure. And I have to make this comment because just last month, the Chief Justice, John Roberts, had addressed the 94 Chief District Judges. And he highlighted that the amendments to the civil rules that took effect on December 1st, 2015, Rule 1, I can read it out here, that says that these rules govern all these rules govern the procedure in all civil actions and proceedings in the United States District Courts except the state of Illinois. And here's the big change here. They should be construed, administered, and enforced by the court and the parties. This is the new language. And the parties to secure the just, speedy, and inexpensive determination of every action and proceeding. I think the sentiment by attorneys is we're advocates. We're here to represent a client, and so long as we comply with the rules and get what we need and want, then we've done our job. But professionalism goes beyond that. That's your battle for that one case. But we all have other ongoing battles or disputes. And we need, sometimes, for civil litigants, I see them on the plaintiff side, then I see them on the defense side. So you can be the giving side or receiving side. And you need to plan ahead that you may be on the other end. And how would you like to be treated? So the professionalism really does supplement. It is not the floor that may be the ceiling, maybe beyond the stars.
Yeah, I would concur in that and add that the ethical rules are not the sole measuring rod, so to speak, for professionalism. Professionalism calls for more than adherence to a set of rules. It's a call for a higher order or a higher purpose of things, a dedication to civility, skill, business practices, in service to the common good. So it goes, from my perspective, it goes way beyond ethical rules.
So as attorneys, as advocates, our motto is probably do unto the other attorney before he does unto me. But professionally, it should more be the golden rule, do unto others as you would expect them to do unto you. Is that something?
And zealous advocacy doesn't mean hostility. You can be, and it doesn't mean dishonesty. I find particularly in the settlement conference context that the more you're able to be direct with me, particularly when we're in caucus sessions, the easier it is for me to try to reach a resolution. And posturing, particularly in settlement conferences, gets us nowhere. Holding back evidence that shows it's the strength of your case is not going to go anywhere as far as us trying to settle the case. Sometimes putting your cards on the table in the beginning is in the best interest of your client because it's going to resolve the case earlier. So when you want to hide things, you really have to think, is this necessary for me to hide? And do they probably already know? Or is it really going to be that smoking gun at trial? How many smoking guns is this? You know, how often do we have a Matlock episode where they admit, yes, I did it, under your cross-examination? So particularly in the settlement conference, I would encourage you all to be, many are collegial. But, you know, Matt Smith is a great example, I think, we can all take for someone who really knew how to work with other attorneys. And I had the pleasure of dealing with him at the settlement conference as well. And it just, the way he treated the opposing counsel, the way he treated the client of the opposing counsel, you know, that was a good example. So many of you can pull from that example. And mentoring, I think, is another huge thing that you can consider. Younger attorneys should find someone that they think does a good job and call that person up, watch that person. It goes a long way. I think Scott has a comment.
Yeah, Matt Smith was a great mentor, and Matt Smith was a great mentor. And if you think that he was collegial and civil to deal with as opposing counsel, you have no idea what it would be like to work for him as an employee and a partner. But the magistrate judge mentioned collegiality and civility and honesty. Honesty is something that is incorporated into the ethical rules. But I've had cause to do research on the other two topics, collegiality and civility, and the model rules of conduct don't specifically mention those whatever you call them. But anyway, there are rules in other districts and other jurisdictions that do address those topics. I know, for example, I think Indiana lawyers, when they're in law school, actually have to take a course or a component of their training in law school deals with the issue of civility. But a lot of people don't realize that even though the model rules don't specifically speak to the topic of civility and collegiality, it can be a violation of the model rules to act in an incivil manner to opposing counsel and parties. It can be seen as prejudicial to the administration of justice, for example, and it's just a source of stress and frustration that none of us really need. So even though Mr. Ernest made this disclaimer at the beginning that we won't be held accountable under the model rules for acting in that way, you actually can. So I've done the research on that.
Thank you. If I can add, I think just as Ina's pointed out, what the attorney should be considering when they're addressing the trial court. Well, remember, the trial court in many instances has a lot of discretion. And when you start showing and exhibiting some unprofessional conduct, guess where that discretion is going to be exercised for?
I think that's our next question. Question number 7. Does exhibiting so how? Because it can't be whoever has the nicest suit wins, right?
Well, for one, it shouldn't hurt your client at all. So that's the norm, right?
Again, a high degree of professionalism definitely helps the client. It adds to that overall perception of having the public having confidence in the integrity of courts. And I mean, to have a client sitting there watching an attorney get angry, emotional and stuff, I don't think that serves the common good, and it doesn't serve the interest of the client. The client's sitting there watching an attorney getting outrageously emotional and stuff, especially when there's no jury to impress. You know, it's I don't think it's conducive to good practice.
You've probably heard the saying, counsel, I think you have a winning case, but you're losing it for your client. I guess referring to the attitude of how counsel is presenting himself or herself to the court. That speaks volume, I think.
Now, I don't know if this will, if I have an opportunity to raise this at another time during this symposium, but one problem goes to an attorney's preparation, of course, goes without saying. You need to be prepared when you come to court, especially from the Attorney General's office or someone else. Oh, this isn't my case. Oh, then why should you be here? Tell your boss, my instruction. Tell your boss you're not going to court unless you have time to review the case. Otherwise, it's a waste of everyone's time. But professionalism in the criminal arena, sentencing. Most attorneys for sentencing never take the proper time to prepare their client for a proper allocution. It's, okay, now Mr. X, I now give you an opportunity to say anything you would like, not under oath. Do you have anything to say, the attorney? That's it. And there's been a study how many, it's back and forth, that how judges are affected by allocution. I myself have been affected by certain allocutions over my tenure here. Much more so than attorneys' arguments. But this is something where attorneys and the ABA and other forums have written articles in this. It's a major subject if you look for it. It's there. How attorneys really drop the ball in not preparing their clients for allocution. Of course, in many cases, if you're going to appeal, it could prejudice your rights, and that's a factor. But if that's not a factor, then there should be more than just that 5-second whisper, oh, tell me sorry, or something like that. It means a lot.
You can test that before Judge Camacho, right?
I'd just like to make a comment because, you know, before I became an attorney, I was a client, and one thing that I noticed in the small community is that, especially with the older lawyers, you know, you got to consider the client's interest. And with people working on multiple cases for so many years, it seemed to me like there's some kind of collusion, there's a buddy system, it's a fraternity, and you're not really using the law to advance your client's interest because, you know, you're worried about making a deal with some other case. And so I think it's important that, you know, we not take this professionalism too far to the point where our clients suffer because, you know, we're not doing our absolute best within the ethical rules. And one example that comes here is, you know, and I got this wrong on the MPRE practice exam, is the scheduling accommodation. I understand that the client controls the ends, and if the ends is going to result in a default without an extension, then that should be, I think the client should prevail. What is your opinion on that? Because there's some controversy regarding that, you know, 20 days to answer 21 in the federal court. If the client says no, don't give them the extension. Is that within the means or is that within the ends? If it's going to result in default, then presumably it's the ends. Get your views on that.
Well, Charles, I think there are 2 parts there that concern me. First is this reference that collegiality may mean that two buddy-buddy and that you're willing to compromise one case over the other. And that's unacceptable. I think let's make sure we're all clear that your duty of loyalty to every client is absolute. And you can't compromise one client's interest because you're negotiating another client's interest. So I don't think, and I hope that, and maybe that's why we're having this discussion here, that none of the attorneys would ever do so. Maybe it's an appearance from, as you mentioned, when you were a client, that it is strange that at the end of a proceeding, whether it be a trial or motion hearing, I actually love it when I see lawyers go shake hands. That's something that the clients and the public have a hard time accepting, that that's actually permissible and encouraged. It's the civility. I mean, how many lawyers have actually ever done it just once even? Not necessarily here. I see one hand. How many? Please? See a lot. That's actually expected and encouraged. So the collegiality is really something that's long beyond the individual attorney, beyond the case, beyond that courtroom. This is a very noble profession, the legal profession. That's what we're trying to increase it. So that's the first part. The second, as I understood your question, pertained to, say, the client trying to control and making a position, say, for example, the consideration of extensions. I mean, the bottom line as an attorney is there's some things that you have some discretion, and you can tell your client, say, well, if I don't, the judge is going to give it to them anyway, because that's within the judge's discretion, not you. And it's just going to cost us money, and sometimes you get sanctioned for that. So if your client wants to pay for that, that's unfortunate. And I think it comes to educating the client, that there's some things that is discretionary, extension of time, that's permissible by the rule, but that's within the judge's discretion. So I would encourage you in that scenario, or any attorney, to educate the client. And in fact, as you pointed in the standards of professional conduct for the district court, I always have to remind the attorney that the client shouldn't, their attitude and their sentiment shouldn't permeate to the attorney that it would then have the attorney carry that sentiment. That's why you need to be a step away from your client's emotional status. Remember what they always say, that the attorney that has himself or herself as a client has what? Exactly. That's one.
And I think what Judge Mangalia has said, I got to talk with my hands, about that. What Judge Mangalia said and what Mr. Ray just raised is, I think, the essence of the debate, which is, are you a hired mouthpiece for your client, or are you a counselor who advises your client, okay, you may want to object to this continuance, but actually overall it's a better strategy for us to handle it a different way. It's your job oftentimes to talk your client out of those unreasonable decisions and explain to them why it's not a good idea, because you're not just a mouthpiece for hire. You're not just someone who's supposed to get up there and pound the table to make the show for your client, because overall it's going to affect that individual case and all of your future clients. Your credibility, while it shouldn't look like conspiring with the opposing counsel, but your credibility is important for all your clients, that client and future ones. And my experience has been, actually not from the attorney or the judge perspective here, is that we're in a small community, and sometimes I'm surprised about how contentious we actually can, how the bar can actually be more contentious than I thought. And part of it is the possible showmanship for the clients. But I don't think that's always effective. If you say, this is the most unreasonable, he's misapprehending the law, he's completely without merit, it starts to affect your credibility if there is some merit to the argument, but you do disagree, and you may have a stronger case. I think that was a great question.
Okay, moving on. Does professional...
Can I ask you a quick question?
Yeah, sure.
And this is a little bit of a self-interest involved here. But how do you feel about the ability or the effectiveness of the court to impose, because Judge McGlone has said several times the word sanctions, and how do you feel that and unfortunately I am speaking more of the superior court, but how do you feel the willingness of the judge to take control and kind of impose a limit on what will happen in the courtroom? How do you feel that affects and gives a cue to attorneys that, oh, you can do whatever you want because you're not going to get sanctioned by the judge. The other lawyer can say or whatever he wants to do, but the point is the judge isn't going to really take control of the courtroom.
Yeah, my court, I think management of the courtroom is a high order. It's a high priority. And I strive to manage that throughout my time on the bench. There's only been a few times where I've had to give a warning that sanctions could be coming if the conduct continues. And there's different methods like that. As you know, in the federal courts, they have a summary contempt. And I did that once in sitting in the district court here. There was one of these people who, quote, didn't believe the court had authority. He was brought in, extradited from the states, etc. In any event, he kept, and I read him that sort of riot act 2-3 times. In our Superior Court, I'm not aware of a lot of sanctions, hardly any at all. And compared to other jurisdictions where you come in late, you're sanctioned. You know, over here hasn't been that policy or procedure. You don't comply with certain rules, you're sanctioned. If you look in any disciplinary or any of the court, other jurisdictions, and the majority of them, they're sanctioned. You need to file an excuse. If an attorney doesn't show up for a hearing in my court, or at the last moment after we've done research on the motion and prepared for it, and at the last minute the motion's withdrawn, I won't allow withdrawal of the motion at the last minute. It's just totally unfair. So, yeah, I think that's important to, I don't know, if an attorney comes in later, doesn't appear in my court, if it's non-appearance on a scheduled hearing, I will inform the clerk on the record to contact the attorney and find out what happened, and I want a written excuse before I take further action. If it's a repeater, then of course I may take different actions. And they've only been very, very rare in my experience in court.
I think what Mr. Bello says, he touches on what we were talking about in our dry run earlier this week, was I sort of, perhaps inadvisedly, said, so what? You tell us to be nice, but we insult each other in our briefs, and then nothing happens. So what? Yes, I've fallen short, and that is my fault, but ultimately, isn't it, and yes, as a professional, it's my responsibility to act professionally, but can't an argument be made that if you allow it, you condone it, it's really on you. You're the captains of your courtroom. I'm saying with the utmost respect.
You should say that first.
But if I do a motion to compel and I attach as Exhibit A through B through B12 emails from Mark Scoggins and I going back calling each other and our mother's horrible names and you're a liar and no, you're a liar, and we would never do that, of course. This is just for an example's sake. But what happens when that goes before the court? Does anything happen?
Yeah, well, it's a really good point that Mr. Bell's raised, and I've been confronted with that all the time. And when I was an attorney, I said if ever I get the bench, I would practice what I preach, and I try to do that. And I can relate to someone who's following the rules 100%, and the other attorneys Friday late and calling names and all sorts of unprofessional tactics. But when it comes before the judge, if it's in a brief, it has a different effect than if it's in open court. In open court, it would never pass without some comment or some action from me. And I think that should be. It should be that control. In a brief, it's different. In a brief, I think the comment should be there, but whether or not sanctions are appropriate, we're dealing with the issues at hand. And they can distract from that. But I can relate to the feeling, well, how come he did all these things, he's getting away with it, it depends on the case-by-case basis, I think.
I would say that, let's start with the briefing attacks. On one occasion, one counsel filed something without filtering, hit the send button, filed. That was a big no-no, and it was caught. You know, the bell's been rung. But one of the best things that that attorney did is recognize the fault and mea culpa. I mean, some lawyers need to learn how to use that word, that phrase. And how do you unring it? You can't, you know, retrieve it. It's not an email, it's CNMI, you know, the electronic filing. The best you can do is come forward, put in writing, come forward in court, apologize personally, and offer some other remedies. There's some magical things that we can do on the court side, such as withdraw that brief and substitute it for the more filtered down basis. To recognize that someone just was venting, you know, that's the human aspect. But the most important thing that can save your practice for the long haul is recognize your mistake. I've had a seasoned attorney also file some brief, unbelievably with the wrong standard. It was called out by opposing party, and that's the first thing counsel said. I know it wrongly, I know that, I don't know why I did that, and it's got my name on it. Apologized, recognized, and adopted the proper standard. So it's important that once it's written, it be recognized. If you don't, and this is the problem, is there are sanctions. I mean, I keep saying, Tim Bell is here saying, what's the sanctions? What are the possible sanctions? Well, the other side say, you know, deny them whatever relief they're asking for and give me my attorney's fees. Sometimes I've ordered sanction where counsel has to pay the fee, not the client, because it was counsel's fault. I've had counsel say, I'll pay it. Don't let my client, you know, it's not my client's fault. And this is the, 5 years that I've been over in that court. Now, if I were to go to my experience, you mentioned, Tim, about the Superior Court. Yeah, it's every courtroom has its standards, and it's true. We as judges have to maintain the integrity as well. Just yesterday, I had a hearing because I had a case where counsel was asking all these extension other things. I denied it, but I said, I warned them, I am not going to give you any more, and I didn't. I had to stand by my words that I'm not going to do that. And so counsel showed up and recognized that I had to do what I had to do and didn't fault me for it. Because it wasn't my fault. I've already been exercising my discretion, but counsel was not performing. So I do agree that, you know, this professionalism goes not only to the attorneys but to the judges as well.
I know that in the last 2 years, the Supreme Court has issued, I think, monetary sanctions in 2 or 3 cases, as I recall.
And one last comment. Of course, it's always incumbent on us to send a message to the, make a report to the disciplinary committee also, which I've done on some occasions.
Okay, that's why I said earlier, and I realize there's some new people here. When I said I had a self-interest, didn't mean I had a case that I wanted sanctions. I had a self-interest.
You just gave us an idea.
Sometimes we're in there and we're going, why is this complaint here? How come the judge didn't take care of this when it was in front of him? So I'll be a little more direct on that. And then my last comment is I'll backtrack like Mike did and say, you're here as representing the judiciary, so I'm making these comments. It doesn't mean that you're personally, you know, that you have problems in this area, but I think we need to get that subject out so that everybody can air it out, so you can see that the bar has a concern too, because as I said, if we're going to say everybody should abide by this rule, then they're going to say, well, the judge should also enforce it, because otherwise then I'm just going to look ineffective in front of my client because the other guy's doing whatever he wants and the judge does the same thing.
Mike, you know, your question number 9 says, does professionalism go beyond the courtroom? And I would just like to add that, you know, when the attorneys deal with our front people, like the clerk's office, or JAs, or secretaries, and even the probation office, please be respectful over the phone or in person, because word gets to us on how attorneys treat the clerks in the court's office and all the other offices here in the court. So just be mindful of that when you deal and talk to over the phone with the court staff. After all, when you take a look at the oath of attorney, it says that you have to be professional to court staff, justices, judges, and just about the whole world.
So while doing research for today, I found this quote: "Justice may be blind, but she has very sophisticated listening devices." So, do you guys? I can't say you guys. Do judges? Wow. I'm a bit flustered. Do judges and justices take note of attorneys' actions that occur outside of the courtroom and outside of the clerk's office, but in public? Restaurants, bars, sidewalks?
I keep inviting my husband and say, we should go over to Godfather's one night and just shock everybody. He hasn't taken me up on that offer yet. Please don't. I just need to know how many bottles or cans you've had. I think that there's some unspoken rule, shall we say, that, you know, I used to be a prosecutor, and boy, did we celebrate when we got the victories, right? So I didn't want any judges around. I know how that feels. But at the same time, we still have an appearance to the public. Not just as judges, but as lawyers. Especially if you're representing, say, the CNMI government. Right? You're standing for the law. And if you're a just, quote unquote, just private attorney, you're still representing an honorable profession that many people are really jealous that you have, that you're an attorney. You command a lot of respect. And so it does matter. If you associate with certain individuals, it may impact our case. I've had to have my conversations with law clerks saying, you cannot socialize with certain lawyers. Why? You know, it impacts our work and the appearance. We need to maintain the integrity. So yes, we do keep track, and we kind of filter that to say, okay, it must be one of those days again. But when we assume our positions in the courtroom and our respective roles, we do expect everyone to be prepared, sharp, and none of the other activities. It's interesting, some outside activities have actually filtered into my court proceedings where it was never, you know, part of the investigation or type, and that's going to be unfortunate. If it's more of an excuse and justification for some sort of a discretionary relief, of course we're going to need to hear that, right? But it's not necessarily the positive relief. Sometimes it can be the negative, so be careful.
It's hard not to know something like that in a small community like this. We go to we get restaurants all the time, groceries, weddings, just about every birthdays that you can count on. And when you hear something or actually witness, you know, things that are going on, and when this attorney comes up as part of counsel of either parties, we sometimes have to evaluate whether we should recuse ourselves or not. So that comes into mind. Just want to let you know.
Yeah, and I think that the younger attorneys or the newer attorneys to our community sometimes forget that. There'll be people in the community, whether you know them or not, they know who you are. If you're a law clerk, they know that you are the law clerk to Chief Justice Castro. Sometimes it's shocking. And you forget that you're at Godfather's, or as an example, or somewhere else, and maybe you have a loud voice like mine. Maybe you've had a couple of drinks and you're in the middle of a story and you're talking. People hear what's going on. So, you know, the wise advice is when you're talking about any of your cases or what's going on, lean in, quietly speak, or do it at home, or just keep it with your girlfriend, boyfriend, husband, wife, partner at home. Because having lived here a long time, there are many, many stories of things being overheard, and you wouldn't want it to be overheard, and you don't want it. Go to that bar graph we had in the beginning. You want the community to have a good impression of you. You do have the advantage in the Commonwealth. I think our bar might be slightly higher than what we saw. I think generally people do respect lawyers in the community. So I think it is your responsibility and our responsibility to uphold that.
So moving on, we're running short on time. We have about 10 minutes left. I'm going to consolidate questions 11 and 13. Are there, and this is for the entire panel, are there particular instances of unprofessional practices that you see often in practice before your court? And as a jurist, what single action makes you look at an attorney and think to yourself, wow, that attorney just doesn't get it. How unprofessional?
unprofessional practices in court at the risk of being repetitive, not showing the proper, not participating in the proper decorum and demeanor in the courtroom, not standing when talking, body language, just slouching the chair, or something without the proper address, talking in court, especially if it's loud. Of course, attorneys always have to maybe talk to the clients in the back while they're waiting for case and other things. Those things are permissible, but constant, in general, a disrespect for the court. And I've seen that in several occasions, much more than I care to remember. And at times I'll just give a note to the marshal in the court, telling him to do that. And in my court, hats come off unless there's some medical reason to keep them on. Maybe it's old-fashioned or whatever, but hats in public just don't make it in my courtroom. And just a general atmosphere of respect and demeanor. And violations of that can take a number of ways: in body language, in verbal language, and just in conduct in the courtroom.
In the Supreme Court, I see this often in briefs, parties calling names, all sorts of names about the other party, the opponents. You see these names in between the lines, but you pretty much know what they're saying. I can tell you pretty much it's not entertaining at all. A lot of times we need to try to just skip over those non-issues, non-case related arguments. I mean, it's not nice, so just don't do it. By the time the parties get to oral argument, they're pretty much in good terms, and you don't hear any of that. But we see them often in the briefs.
Sometimes it seems like pleadings are written more for the media than for the judiciary. Anyone care to comment? Am I off base, or do you notice that? Is that professional? Is that good lawyer?
I think that everybody is aware of these motions to strike, certain language that are very, really, it's just inciting some negative responses here. So I must say that on most of the filings in my court, at least in the district court, the attorneys keep it simple. But it's fair game to state it accurately. But once it looks a little bit salacious and all, that's when it becomes problematic. And motions to strike get used quite often. So it's just not worth the while. And I think everyone should just remember that it's with the court. If you want to have any additional information conveyed to the media, have your own press conference.
When we have those introductory languages and sound bites, I think the attorney just wasted an hour of his time writing it, because I just skipped it. All the creative writing or the nice phrases that undergrad English majors write, I just skipped those. They don't have to be arguments.
Well, for the last 5 minutes, I'd like to open it up to anything any panelists would like to say, or any question or statement any audience member would like to share.
If you're having issues with briefs, name callings, and things like that, I think it's a good thing to just pick up the phone, call the other party. It might be too late for us not to hear it, but apologize to the other party. Usually that works. Even actions in court, I've seen it a lot of times where I'll call parties into the office and I tell them, look, I don't think it's a good idea to be entertaining your clients this way. It certainly wasn't entertaining to me. We apologize right there, and they move on to the real subject. So pick up the phone or invest in a $5 lunch, and that could get you mileage.
Well, for me, I'll be missing the interaction with all you fine attorneys in CNMI. But one thing I've always advocated, you know, on a lot of times things will fall through the cracks. Attorneys have a case, they want to. It's not uncommon to have a motion for a status conference just so the attorney can find out what's happening. Well, this is, it's really not necessary. In my court, and I think in any other court, just call the clerk, call the judge's secretary. It's not an ex parte communication because you're not talking to the judge, and just ask me just following up on that case. I encourage this. And on several occasions, my secretary or my clerk would come in, so-and-so called and he wants to know about that case. And it wasn't even on my list. It wasn't even on my table. And I was so glad that it came to my awareness. So, you know, those things do happen. So in my opinion, there's nothing improper. It's perfectly, it helps matters go along. Just call the judge's secretary or the judge's clerk of court and just give a follow-up. The message will definitely get back to the judge. It's not guaranteed the judge will do anything about it, depending on what judge, but in my court, it's always been the case, and I welcome that.
So earlier this week, we had spoken, and we noticed that it was about my age is about the cutoff, where I'm very comfortable getting a case, and one of my first, other than calling the client, is to call opposing counsel. And I've noticed that the older attorneys have no problem picking up the phone and calling, and the judges seem to expect us to pick up the phone and call. But I've noticed that younger or newer attorneys, tend not to want to call, and they tend to want to email, and they tend to want to text. Magistrate Judge Kennedy, do you have any thoughts on that? Or?
Yeah, we had talked about it through our dry run-through, and the trend in the U.S. is particularly dealing with discovery disputes, and where Judge Magnolia is looking at a change to our local civil rules in order to meet the meet and confer requirement that you actually have to meet in person or by phone. And because we all encounter this. You put something in writing, even if you don't intend it to come out hostile, it maybe is interpreted as hostile on the other line. And if you just have a conversation regarding it, I think it will help. And Mike's point was, you know, younger people maybe don't want to communicate that way. And my response was, whether you are 26 or 46, it's a lot harder to say something nasty to someone when you're looking at them or when you're on the phone with them. And so it will go a long way, I think, to resolving discovery disputes if you actually pick up the phone.
This reminds me of a TV program I saw several years ago here, and it was about a local family, and they were interviewing the grandmother. In the backyard and the picnic table. And she says, and look, here's my two grandchildren. He's 12 and she's 10. And they're sitting across from each other, texting each other. You know, it leaves a lot to be desired. That personal confrontation, that personal contact is big.
I saw Sonia sign go up and stop, and I can't remember, but practice what you preach.
I actually started looking at, in some of my cases, and I think some of the attorneys would know this, both criminal and civil. If something is brought to my attention, either from my own reading or from what my law clerks have caught, and we're trying to stave off a big problem, unnecessary expense or in hearing, I actually say, well, call up a conference call. Just tell my JA, reach out to the attorneys. It could be an hour later, and it's normally it'll be done in 10, 15 minutes. Quick conversation, hear everybody out. I would air out one of my concerns because I want to move things along. My style has always been take some action and set another hearing date so we don't lose track. But when we see something developing and we already see it brewing, we try to take action. And I do encourage, in our local rules, we do have the rules that allow the parties to reach to the court to resolve an immediate discovery dispute. Say you're in the middle of a deposition, for example. That's permissible. I've done that. Magistrate Judge Kennedy has done that. So you have a problem. Why waste your time of resolving everything? Everybody walk away and go file. We want to move things along. I read the first Rule 1 of a civil procedure, so it's one that I think everybody should be practicing, both at the bench and the bar. I see someone's about to pull the cane on me.
Okay, thank you very much. Good job by our moderator, Mike Ernest. I think Mike was very nervous coming at least because we wanted to be like Ellen or Oprah, right, Mike? And I think it did work. Yes. And thank you to our distinguished panel members. We have a little bit of certificate for you by the bar president, Lilian Tenorio. Do we have a certificate for the moderator?
Yes, we do. I remember.
Okay.
Very good.
So the president will give you a certificate of appreciation to Michael Ernest.
I think it's back there.
Okay, Chief Judge Ramona D. Maloney.
No, it's here.
CNMI Court Assistant, Rocky B.
And it's spelled correctly.
Justice Barry B. Enos.
But I will give you one, because you're pinch hitting today.
Okay. Associate Judge David Weissman. And Magistrate Judge Heather Kennedy.
And Mike, can you come up again?
Thank you. Okay, so we are...
Actually, I have one to present to you because you've been very helpful. You and I are sort of pinch hitting because Ned is somewhere in Fiji enjoying the scuba diving down there, but we managed to...
So, to John McLaughlin.
Yes,
I wish we could have more of this, and I think the CLE committee should try to invite the judges and justices in future conferences because we had some very good discussion in our first panel. So please do invite the other justices and judges for not only professionalism, but for other issues that face the bar. Thank you very much. We have a 10 to 15 minute break, and then another set of panelists will come forward.
Okay, and now can we go to the first slide? We're going to begin with this segment is 90 minutes long, by the way, and we'll start with this first question.
It'll seem longer.
We're going to be hungry by then. So this is the first question. What are the merits of civility, and how do you maintain civility with other attorneys? Who wants to start?
Well, obviously, I think you've heard some of the things that we're going to say probably repetitious of what you heard from the judges and Justice Enos. The civility issue, Rex and I were talking about this just before, we had our personal dry run. We didn't have a dry run as no, we weren't invited. We could have had one. Actually, you're looking at 3 of the members of the disciplinary committee right here, so we got a majority vote here. So the civility thing, it's kind of like, you know what it is, right? I mean, I can do synonyms, courtesy, you heard one of the previous panel members talk about, if you don't throw the first rock, or if you lose in the glass house, that whole saying. So my point is, it's kind of a reciprocal thing, and you know what it is, and you should understand it and you should follow it because it's a good thing. But as far as the client goes, I think it makes more sense because it's the economical and it's the most efficient way to litigate. Because if you're dealing with some other person on the other side, it doesn't matter who it is. It could be Ted Mitchell. For those of you who are older, you'll know. If you deal with somebody, no matter how unreasonable that person is, if you still maintain your ground and you're civil with that other person, then the bottom line is that has to somewhere along the line breach that wall that you're pounding against. And so my point is, If you engage and reciprocate with what the other person is giving you, then what's happening is you're spending the client's money on doing things which are just merely, vendettas and back and forth vengeance things which don't advance the client's cause at all. And you've heard from these judges and justice that when they look at that, that belittles you. I mean, because when you put that stuff in your pleading, you're basically saying, I'm willing to engage in this fracas that doesn't tell the judge anything about whether or not your client should win his actual case. The good example was, and like I said, it was just discussed, was the thing about the continuance. Absolutely correct. And Judge McLoney said that this is an area that the judge, 99% of the time, the judge is going to grant that motion. So why would you tell your client, oh, let's not give him a continuance. Let's make him file the papers in the court. Well, if he files the papers in the court, you've got to file an opposition. So you've just spent X number of dollars of your client's money to oppose a motion that you absolutely know that guarantees. The guy can say, I had a hangnail, and the judge is going to say, okay, I'll give you 10 days or 20 more days. So the bottom line is, where's the efficiency there? Okay, so that's the kind of thing that I think illustrates that courtesy and some sort of professional courtesy doesn't show that you're a weak attorney and you're representing your client.
Yes,
Let me approach the same question from a different aspect, which is that all of you have chosen law as your profession. When you get to be an older attorney, as Tim is,
and there's Charles calls.
You'll find out it's a very tough profession. It's tough on your marriage. It's tough on your family life. It's very tough on your children. And what makes it tough is the stress involved in the profession. And so civility works. It makes for a better working atmosphere. If you can get along with your so-called opponent so that when you need a continuance, you're probably going to get a continuance. And that's because you extended that same courtesy to that person before. Or that even though you're in the heat of battle, you still aren't calling each other names and you can still be friendly to each other in public. It's going to take a lot of stress out of your life. How many times do you know that you've had a problem with someone and you're driving down Beach Road and you see their truck approaching and you turn your head the other way because you don't want to look them in the eye? Or at least it used to be that way on Saipan, that you knew who you had problems with. You don't want to be overlooking people because you have problems with them. That's a sore point in your life. That adds stress. You want to be looking at people in the bar with a feeling of collegiality. I mean, I know that this morning when I came, it was really good to see some of you. It was good to see many of you here that I haven't run into for a while. And that's really, we're part of a group that have all gone through the same experience of going through law school. Those of us in private practice have the same experiences with dealing with difficult clients to control, or unrealistic expectations, or difficulties in dealing with government or courts or whatever. We all have the same problems, so we have a lot in common. We should get along with each other. So civility works in your personal life. It just makes it a lot less stressful.
I'd like to piggyback on Rex. When I was looking at these questions, I really thought about the question about merits of civility. And aside from, having less stress from dealing with someone who's belligerent or myself being belligerent, there's also an efficiency and a cost aspect to your client. I've been in private practice since I started in Hawaii, and I was really shocked when I was court appointed to things here that I didn't really want to practice in. That's where I think I've encountered most of the issues with civility. And oftentimes I end up spending twice as much time, dealing with things that are irrelevant to the case at hand. And you have to sit down and think, well, what do I do here? I'm not going to bill my client for that additional time where we dealt with scheduling issues or just extensions. Well, so that cost is on you as the attorney, and also then you've also just kind of wasted about half an hour of your time or double that time that you could have spent on another client. And there's just that cost aspect. But coming from a small island like, I guess Oahu's not that small because the bar there is a lot bigger, and then coming here to Saipan, where it's even a smaller community, I've also learned, I mean, I've only been here for 4 years, and I don't recognize a lot of faces here, and I kind of wonder why I'm in the panel. But reputation really matters in Saipan. I had to really get used to, people recognizing my car being parked at establishments and saying, hey, so-and-so, saw you the other day parked at this place, or staff at restaurants was saying, oh, I saw your husband here with another woman the other day having lunch, and it's like, what? Things like that get really odd. But it's just people being friendly and people knowing who you are and what you do. And it's not just your reputation being affected by whether or not you're professional and you're civil to opposing counsel, but it's also the reputation of the whole bar. And I think there were discussions earlier about how you treat staff in court, and even just how you treat the staff at my office. I mean, if my staff will tell me, oh, so-and-so called earlier and they were saying, asking these really rude questions, or their tone was really polite, that's going to, affect how I see you as an attorney. And vice versa, if I acted that way in calling your office and talk to your staff in that manner, I mean, my reputation is on the line. And I guess being in private practice, my reputation is my currency. And if I'm trying to develop clients and they've already heard about what I'm like, I hope that it's going to be something positive. Otherwise, I'd rather that they have no clue who I am, rather than some kind of infamous or disrespectful situation that they've heard about. Jen, do you want to chime in?
Well, I'll just say, I'll have the practical statement maybe. When I saw how do you maintain civility, I thought for myself at least, what's the practical answer to that? And I'll tell you a few things that I think are real world good things that I've done for myself, and that is get a sounding board. Have somebody else to bounce things off of. Don't make the decisions all by yourself. If you think you're being treated poorly or somebody's being unreasonable, go talk to somebody else. The judge panel, the justices and judges this morning talked about getting a mentor, and I cannot say or overstate how important that is. So the first thing, to maintain civility, get a sounding board, learn from somebody else. The other thing is to get perspective, step back from it. Step away from it. Take a breath. Don't respond without thinking. Those are the kinds of things that allow you to actually maintain civility, because it's easy when the other party is friendly with you, which is 99% of the people I work with.
It's pointing at me.
99% of the people I work with. When you're challenged is when the other person is not friendly, and that's when you have a chance to show your colors. Get a sounding board, get perspective, take a moment, and don't let the other person's behavior affect you. And that's really practically what works for me.
Okay, so what I'm hearing then is try to be civil with each other. It's cheaper, less stressful, and if in doubt, seek a sounding board. Okay.
I also have one more practical thing to add about how to maintain civility. I guess I'm part of that younger group of attorneys who text message and prefer emails. I have gotten used to just calling people, especially as I get to know the other attorneys in the bar. But one advice I got from an attorney that I worked with at Carl Smith very early on, I wasn't interested in litigation as a practice area, to be completely honest. I wasn't interested in the war and the fighting and the litigious aspect of it all. And I was more interested in transactional work where my clients would actually want to be there. But this litigator, a partner of Carl Smith, he was just always very friendly. He had this huge dimple, and even when he wasn't smiling, he just always seemed like he was very cordial, and it always worked to his advantage. But one of the tips that I got from him, two, that I'd like to share is, one, oftentimes silence is just really kind of very useful. I've faced just pro se litigants or opposing counsels, and sometimes just sitting there and kind of nodding my head, not necessarily in agreement, but seeming like I'm thinking about it, and that's what he said. It's helpful, and just conveying that, okay, we need to just kind of calm down and think about being professional and civil. But also, one practical tip that he gave me is always read your emails before you send them out. I know it takes an additional step. But even when it's like a really, really short email, sometimes you miss a word like not, and you just sent it off, and the other person at the other end reads it, and it's like, wait, what? What's going on? I mean, pretend that communication is going to end up before the court, and think about how that affects your reputation, affects how the audience and the other person reading it could take your message. And I don't think it's, unless it's going to be a really long email, it takes a lot of time to do.
Thank you. Yes.
I want to add on to the question about how do you maintain civility, because I think it's really a tough question. I mean, I think I had the same reaction you did. Why was I called on this panel? I'm sure several of you probably go, well, I've seen him act uncivil before, and I would admit that I have. We all have our hot button issues. We all have certain things that really frustrate us. And I think it's worth sitting down and thinking to yourself, what pushes my buttons? So that you have some self-understanding. Maybe it's a person who makes the whole court process a mockery because they ignore the rules. They don't turn in documents they were supposed to turn in with their brief. They don't respond to your brief and they show up to argument. It could be things of that nature. It could be somebody who files a frivolous motion. You go, this is wasting my client's time and money. Why are we doing this? It could be, of course, just the simple fact that a person is rude to you and disrespectful to you. Or maybe to your face, they're very nice, and then you get their brief, and they just rip you to pieces in a personal fashion. You know, you got to think of what is it? Is it, maybe it's you're just tied up in the justice of your client's cause, and it really bothers you that you could lose this matter. Those are all the things that, for me, will push my buttons. And when I'm in that situation, I always try to think about how do I de-stress myself a little bit before I go into a court appearance. I don't drink coffee in advance, which is really tough. But I try to avoid anything that's going to wind up my motor a little bit. I try to go out and exercise before oral argument. Just this morning, Vince and I rode our bikes, you know, as a way of just bleeding off that extra energy. Think about, is this a situation where I'm likely to be stressed? What can I do to kind of bleed off that stress so that I'm not jumping all around when I get into the courtroom? And then, you know, try to keep your cool and recognize that I think occasionally every person who litigates enough is going to run into a situation where they're going to act in a way that's not civil. That's going to happen. I can see attorneys in this room who are looking at me like, yeah, I've been there with you. You know? Yeah, if you're thinking that, I've been there. I mean, there have been times when I've been ashamed of myself when I've walked away from the court. I've done something I didn't like that I did. And in that situation, sometimes if the other person's a halfway decent human, and that's almost 99% of the time, and just go and apologize. Just tell them that you're sorry, you know, and if that's not the appropriate time, then wait till the end of the case. But don't burn that bridge. Go back and try to repair it a little bit. And I found that every time that I've done that, it's worked out very well. And I would highly suggest that. There are times on that, how do you maintain civility, when you run into the really, really unusual situation, the really mean other attorney, but I suspect that'll come up later on if we talk about that.
It will. Okay. Moving on to the next question. How do you deal with a belligerent opposing counsel?
What's the next one?
Well, you know, the funny thing about this is, and this is more going a little bit back to the preparatory, you got to remember, we are the hired guns. I mean, somebody said that as a bad comment earlier. We are the people who are being hired to represent these people. If this was something everybody could do, if you could do it just by walking off the street and saying, yeah, I know what this is about, I know the facts, that's easy. But you've got to apply the facts to the law, and you've got to have some persuasive ability. And sometimes, you know, when you're in that role of, I'm the champion of this person, you know, then it becomes, the reason the civility issue is difficult is because in a way it's not natural, because you want to be persuasive, you want to be the client's champion. The client wants you to be his champion. You know, there's a lot of clients that come in and say, you know, I mean, they don't come out and say it in so many words, but they'll say, you know, how tough are you? You know, are you willing to, you know, bite the other guy or something like that? So that's kind of, you know, that's kind of where we start from. So that's why the civility issue is not user-friendly, or is not really the natural thing. I mean, you can have it on your own personality, and that could be in there, but I want to go back, and, you know, I've got a little outline, and most of my stuff is practical stuff you can do, because we can talk about civility in the theoretical sense, but here's practical things you can do. One of the things that she talked about reading the email, I do when I write a letter. If I'm pissed at somebody, I'll write a letter, and it could be 2 pages long, and I'll put it in the outbox for safety, and I'll leave it there for a day, maybe sometimes as much as 2 days. And then on the second day, I'll throw it away. So what that does is it takes the vinegar out of me. So, you know, I've kind of vented whatever I wanted to say, whatever I wanted to call him or her. I'll say, you know, I'll say it all in the letter, and it'll be a real letter. And, you know, I don't bill the client for that. But the point is that lowers my stress level, and that lowers, you know, because I vented it, and so it's gone. And then I can go ahead and write the other letter and just say, yeah, you know, you mentioned these things, but, you know, I think what we ought to do is go forward, and if we put that aside, here's where we go. And so that practice letter thing, you know, like I said, it does work for me, and I got it off the internet, so I know that other people are using the same issue. So, you know, the point is it's one of those things that really does allow you to vent what's bothering you. So, and then the other thing is, you know, little expressions like kill them with kindness. You know, you've heard that expression. So the reason that's a cliche is because if you meet aggressive behavior by opposing counsel, but you say, well, thank you very much for pointing that out, and then move on, then you've got this thing where you've kind of, in a sense, you've put him on notice. Hey, you're behaving like a, you know, something, an anal orifice, and you know, I am trying to get the jobs done, the job for the client done, and I'm trying to advance this thing, and I'm not trying to. I don't want to have a fight with you because, as she said as well, we're a small bar, and you're not going to, in L.A., New York, or some big place like that, you'll see a guy and you say, I don't care, you know, I'll burn that bridge, right? But here, you're going to see that person, you know, next week, the week after that, next year, you know what I mean? So you burn the bridges, it just makes your job more difficult, because next time you want something from that person, when you said, I won't give you a continuance because, you know, my client said no, what's he going to say when you ask for a continuance? And we all do it, you know, we all need continuances, there's no doubt about that, right? You know, in a place like this, we're all going off island a lot, and so, you know, when you need to go off island, and the guy says, well, sorry, but, you know, remember when you didn't give me my continuance? So, you know, then you sort of got what you started, so to speak. So that's the kind of things that help dealing with a really contentious opposing counsel.
Let me add to on the belligerent counsel. We've had some belligerent counsel on island, and I don't think right now in this bar we would have anyone that quite matches up to some of the people we've had in the past. If you're from the LA area, I was a trial lawyer in Los Angeles before I came here. You know, the guy in LA, it's easier to talk about someone who's not a member of this bar or wasn't. Irving Kinerick was famous. He was just, you know, there was this famous scene, it was actually in a movie, where he got Viz Bugliosi so mad at him that Bugliosi grabbed him by the throat in the courtroom, and Kinerick was saying, Your Honor, I want the record to reflect that Mr. Bugliosi is strangling me. Those sort of people exist, and they do come to Saipan occasionally, and they are really special cases, and they are really difficult to deal with, and I've had a fair number of cases with that type of attorney. And when you encounter that sort of attorney, I can guarantee you're pretty much going to be totally unprepared for it. It will take you completely out of your comfort zone. The closest thing I can say is it reminds me of a street fight. It's very much just out in the back alley, two guys ready to duke it out, and I know individual I'm thinking about, it does get physical, and I think some of the attorneys who've practiced here, know who I'm talking about and how difficult that can get. How do you handle that? Well, I spent, I think, about 4 years or 5 years just handling cases with that attorney and trying to figure out what's the key to dealing with this person who constantly pushes me beyond my comfort zone. And what I learned is that I'm not as good at being a bad guy as the bad guy is. I'm just not wired that way. And so, you know, it becomes almost instinctual with us to fight fire with fire. And when someone gets in your face, you feel like, well, I've got to stand up for my client, and you get in that person's face. And what happens is, you're going to find out, it's a hard lesson, but you can find out they're better at it than you are. Unless you're really used to being a street fighter, they're going to be better at it than you are. That's the first thing. That's a tough lesson to learn. So fighting fire with fire, it just doesn't work. And it doesn't work for another very, very practical reason. And that is that when you do it, that person withdraws at the right moment and you look like the bad guy. What ends up happening is you go into court and you respond to the other person being really bad, and you respond kind of clumsily and overtly, and you end up getting sanctioned, not the bad guy. As a practical matter, it doesn't work. Just time and time again, the nice guy ends up getting into big trouble because he or she tried to play tough with someone who is really, really tough. And you've got to find another strategy. And actually, I'm trying to think of how much I can say. Let me just say this. Though, what I concluded in the end was that my most effective strategy was to be nice. Because that's what the bad guy can't take. And it sounds crazy, but to actually be really nice. And I was in a very contentious depot. It was very, very nasty. I was defending a judge in the courts here, and he was the deponent, and I lost it. I got really angry, and I said something really nasty to the other person. And I sat there for the next 2 hours while I was defending, and that other person was asking questions, thinking, boy, what did I just do? And I reached lunch break, and I said, I'd like to take you to lunch, you know, and I thought, I'll just try that. I'd like to take you to lunch. And he flipped out, got very angry, and, you know, on the record, told me, why would I ever think he'd go to lunch with me, and other things. And he vented. That was fine. That was okay. It's like I took it as my punishment. That was okay. And never saw him again. And that was it. It was the end of the depot.
So the advice is kill him with kindness.
Yeah,
Ask him to lunch.
not saccharine kindness, but a fairly sincere kindness. I mean, you got to find that place in you, whether it's your belief in your religion or whatever it is, something that where you say, all right, I need to be kind to this human being. And if you reach down to that point and you put it forward, I think sometimes these people don't know what to do with that. I'm not saying that's the solve-all situation. Yes.
Rex, there was a guy who used to be an attorney here. You can all thank me for that later. But he would do exactly what you're talking about, which is get nasty, and then when you respond in a kind way, in a professional way, it would only prompt him to get nastier. And he's not the only person who does this, but what people don't understand when they're behaving in that way is oftentimes your opponent is recognizing that you're being crazy or whatever, and they're ultimately going to use that against you. I mean, it hurts the client when you're acting in that way all the time.
When you're acting?
When you're being an ass.
Overtly, oh yeah, yeah.
I'm not by nature a very rainbows and unicorn type of person, but the approach that I found with respect to exactly what you're saying, I agree with what you're saying and what Marcus said. you don't have to be overly verbose with your kill them with kindness approach. I encountered a situation where I was receiving some very intricate, long-winded, and frankly acerbic emails from someone who I think was hitting send too quickly. And my response was not a long-winded, oh, well, yes, we're all happy holding hands. I simply responded with, well, thank you for your email, I disagree. Hugs and kisses, George Hasselhoff. And the response to that was exactly what Mark was saying. This generated another long-winded, even more acerbic email that, in addition to being mean, called me stupid for not understanding what they were saying. And then my response was, thank you very much, I still disagree. And it satisfied my need to respond, but it also gave them the opportunity to be an even bigger jackass. So,
yeah, and I think that there's two things that I'd say about this situation. And one is, when I said that when you try to be just as tough back, and sooner or later you all will reach that point where you say, okay, I'm just gonna give this guy what he deserves. It reminds me, I have a younger sister, and she used to always get me in trouble. And she would, be slugging me in the back seat of the car, and then I would turn and I'd slug her, and that would be just when my parents turned around. And I'd be the one that's in trouble. Of course, she'd just break down in tears, and I'd be left there, with all this guilt, and I would get punished. That's what it's like going up against the bully. Because when you go up against the bully, it's like all of a sudden he or she knows how to retreat and then leaves you with your fist curled up and the judge looking at you, and you go, oh God, I'm going to get in trouble. And you do. And I studied a lot of case law on this for some motions that I had, and it happens again and again and again in reported case decisions about attorneys getting sanctioned when the record shows that it was the other guy that was the bad guy, but this guy got sucked into the vortex. And you just don't want to get sucked into that.
Okay. I'm not engaged in the two
elder lawyers.
But do you think there's a gender, there's a difference when dealing with female attorneys? Because I know that when I was in practice, that I did sense that women tend to be, Jen, you and I have been opposing and on the same side, all at the same time. That's kind of weird. But there is that difference. And I find most of the male attorneys or men attorneys can be very aggressive. But dealing with women can be different. They're a lot more kinder and a lot more civil. But I don't know.
So are you complaining about that? Or?
Yeah, I am. But I want to hear your perspective.
Well, I would say first that I don't think there's enough female attorneys in this bar.
I agree.
And that I don't get to deal with women enough. So that would be my first response. My second response would be, yes, I think it's absolutely true. I also think, at the risk of sparking a debate that has nothing to do with this symposium today, that male attorneys, especially with younger female attorneys, can be extraordinarily condescending and can talk down to you by virtue of your age or gender. I'm not sure. But it's definitely happened. And so when we talk about dealing with a belligerent attorney, if you are young and you are female, and maybe it's just if you're also just young, you also have to learn how to deal with that. And it may not be belligerent, it might be something much more subtle than that, but I think the same rules apply. Get a sounding board, say very little. George's tact is amazingly effective. Thank you, I disagree. When you get unsolicited advice to the new attorneys, you are going to get unsolicited advice from opposing counsel. They're going to tell you, and this is a quote, "It doesn't work like that here." Okay? That's a quote.
He just went away after that.
Yeah, it wasn't George. But that's a quote. Oh, sweetheart, you'll know more in a few years. I've been told that.
I know exactly.
So when you get those comments, it's not belligerence, but it is something that pushes my buttons through the roof immediately. And it does not do you any good to lash out at that. So my advice to that would be absolutely to step back, walk away, take a moment, Female attorneys don't treat each other like that.
I'm sorry, Jen, I'll try to stop.
It's not my main part of the
Wouldn't it be a lot simpler if we just took the last 2 words out of it and just said kind of?
Period. And you can't, and to the young attorneys in this room, just be prepared for it. So when it happens, you have a plan, because it will not bode well. And Rex is so right. You will be the one caught looking like a crazy person, and the other opposing counsel who just called you sweetheart and told you you didn't know what you were doing will be standing there looking as respectable as ever. So be prepared and have a plan.
Now, one thing I want to add is, what if you're the one? That's my little snippet. If you're the one, if you're the belligerent one, and I think Rex hit about the fact that, what are you going to do? You did it. So what are you going to do now? Are you going to let it just die and leave that undertone with the opposing counsel, or are you going to take the affirmative thing and say, hey, I'm sorry, had a bad day, whatever, too many billables, not enough clients paying, whatever your reason was. But I think the other important thing is, how do you know? Because sometimes, we talk about these things in kind of abstract thing, and I think one of the things you can look at is this. If you went in through a situation with opposing counsel, and you're still thinking about that situation and going, did I step out of line a little bit or whatever, and it's 24 or 48 hours later and you're still thinking about it, then chances are you did. And so the point is, that's when you should take whatever remedial action you think is appropriate and just say, hey, dude, I'm sorry, whatever happened, I had a fight with my wife or whatever, girlfriend or whatever, or some other external factor caused me to blow up on that particular occasion, and I'm not like that, I'm not going to do it again or whatever. So that's you don't have to make it a formal, flowery apology, so it doesn't offend George. And so the point is, the object is that there should be ways for you to kind of self-evaluate as well, because we are, like I said before, we are the combatants, and we're representing the client, and so sometimes you take that combative role seriously, and when you step out of line, that's one way that I think you can self-evaluate and see that you need to take remedial action.
Okay, thanks. We need to move on. Question number 3. How would you approach a fellow member of the bar to let them know that their conduct is unprofessional? Ms. Cacharo, you want to start?
I was actually going to answer Lillian's question because...
Oh, go ahead.
But that's okay. Because I was thinking about George's response to the email, and I was thinking that if I had sent that email, I probably wouldn't have gotten a reply, a reply that was really angry and nasty after that. And I wondered whether that's because I'm me, and people know I'm not being condescending with how I'm responding when I use that, and they just assume that because I'm female, I'm Asian, or what is it? Because I've sent responses back like that where I thought an email was really long and just unnecessarily rude, but if I sent a response like what George sent, I don't think I would have, gotten that a really nasty response. But I'm also thinking back to my initial, when I was starting to practice, and I have had partners and more senior attorneys sent me in when things got really kind of tense, or brought me into meetings when things got really tense. And at times this was when I was pregnant, or just because I'm smaller and I'm Asian. I mean, even growing up in Hawaii, I'm an Asian woman and I'm walking in with, male attorneys, and there's a lot of assumptions about how you behave in that situation, I think. I'm not trying to say I agree with the stereotypes or the perpetuation of these assumptions, but I think it's there. I'm just not naturally the type of person who's going to curse back and say nasty things. Like my husband will tell you, I have a really hard time just using expletives, even when I'm like really angry. And I'll just find other ways to kind of vent, but I've used it to my advantage too, recognizing that because I am an Asian woman attorney, that people will kind of come in, I don't know, I guess I expect that the other person, even if I know by reputation that they can be belligerent, I come in with an expectation that if I'm really friendly, that's not really what has happened before is not going to happen. I mean, I've heard of attorneys who are still here who will get really nasty on the phone, and when I'm looking at these questions that we've gotten, the third one, this is really where I wonder why I'm in the panel, because I've not encountered these situations, and maybe I'm just really fortunate that I haven't encountered certain attorneys in my practice here yet, or maybe yet, or I don't know.
Maybe it's your membership in the disciplinary committee.
Never to join.
I'm sure you've seen a lot of complaints.
Yeah, that's not the case. We engender more. The opposite behavior, I think.
So I'll move on to the next question with you.
Okay.
And I'll present the question actually to the two elder members of the panel.
Can we stop with that?
No.
Discrimination lawsuits coming up.
I really my gut response when I saw this question was you don't. And I don't know if that's right. But my first response when I read it was no, you do not, because how is that ever going to be taken well? You're unprofessional. How do you wrap that up in a present that is accepted? I don't think that you can. Now, I will turn it to you, but I would say this. With someone that you are close with and that you have a very strong relationship with, if it is presented in the right way, which is key, you can say to someone, I took some offense to that, or you hurt my feelings, or you made me upset, or I don't think that's going to go well, and you might want to not do that anymore. But you would have to be very careful in the way that was done. I had somebody suggest something to me that I was doing that they deemed to be very rude, that I never even considered as rude. I didn't think it was rude. I thought it was standard practice. They told me that it was rude, and the way that they presented it was terrible. And so my response was basically, thanks but no thanks. Now I don't like you. A couple days passes, and I see this person, and we're friends, kind of. And so I didn't want this tension, and I said to him, in hindsight, that might have been good advice, and I appreciate it, and I apologize for my response, but you packaged it terribly. So that's my only experience, and my response is I would never do it. So I'll let them take it and tell us what to do.
I'll use an anecdote. It didn't actually happen to me. It happened to another attorney I work with, where she was on the phone and another attorney was being very unprofessional and started yelling at her and saying things that were really not nice. Unfortunately, it happened on the phone, so she just said, "You're being very unprofessional. I'm going to hang up now." Hang up. I mean, look, in a situation like that, that's easy, right? But if it happens like in person, I have a really tough time, like Jen, trying to decide what to do. Well, if it was like Sean or Marsha, who I work with, it probably wouldn't happen that they'd ever be unprofessional. I could tell them. And if they told me, it hurt, but because they are my mentors, I take it as a constructive criticism. Now, unfortunately, not everybody is going to take it that way. And I don't know, this is where I'm like Jen, I think I'm kind of too young. And I don't know, I've not encountered this enough, I think, to really know how to best approach it when it's somebody I haven't worked enough with or haven't worked opposite with enough times to tell them directly, even if I want to.
Well, I agree with both of you. I mean, I think that, first of all, if a person's acting unprofessionally, most of the time they know it. And so you're kind of stating the obvious, and what you're just doing is putting out fighting words. So I belong to the school of pragmatism, do it if it works. It doesn't, I don't think it works. Maybe you have some sort of an ethical, obligation to call them on it, but strategically, I'm there to deal for my client's best interest, and that does not advance my client's best interest. I've just pissed someone off. I wouldn't do it. Just wouldn't do it. I would do it if it were Tim, and he was telling me at a restaurant what's going on in one of his cases. I would say to him, hey, I think you ought to back. You're just way too emotional about this. You need to back up a little bit. And I pointed out to him as a sounding board for him. But with an opposing counsel, no. But I do it for Tim all the time.
And I do it for him all the time. Anyway,
it's fun criticizing Tim.
That's one of the things what happens is when you use humor as your diffusing agent, you get to be the butt of jokes as well. But anyway, one of the things that I've got in my notes that is, I call it mystery uncivility. So a guy being
or is being uncivil towards you, and you don't know why. And so, and sometimes I think it kind of fits in with this, because I think the solution is you just say, hey, I'm detecting this attitude or this anger towards me, and I don't know why. Can you explain to me why you're doing it? And so sometimes that can diffuse the situation, because maybe the person doesn't realize they've raised their voice, or maybe, like I said, there's these external factors in the home environment that have caused this problem, and it just sort of tends to be one way to get in there and maybe break down whatever's happening. But like you said, you can't. There's only so much you can do.
Just on a sort of dispute resolution and handling people with kid gloves sometimes, instead of saying, why are you treating me this way, assume you did something wrong. I'm sorry. I've upset you. What have I done, and what can I do to fix it? Rather than asking them to explain themselves, because I think that can push the hot button. It's getting to the same place, but sometimes it can be helpful. But I just couldn't agree with you more. I would not tell somebody they're being unprofessional.
I do think it's helpful, though, when you run into that sort of situation, and particularly what brought it to mind is when Tim talked about someone with a bad attitude. It sometimes is worth stopping for a second and say, how did we get here? Think just in your own mind, how did we get here? Did I do something that offended that person? Maybe that last reply memorandum that I wrote didn't go over well, or maybe they think that I intentionally misquoted the law, or try to think back and replay your relationship and see if there's room for misunderstanding, because there might be. And so every now and then, I think to be a good trial lawyer, you definitely have to have the ability to step outside your body and look at yourself, and look at the situation you're in, and possibly take the other point of view and say, is there room here for misunderstanding? Could I have done something wrong? And that instead of this person just being a really bad person, they're actually a nice person responding to bad circumstances. Maybe they've been told bad things about me, or been told bad things about my client, and it colors their view of things, and maybe I need to approach them and see if we can understand the situation a little better. That might be a way of chiseling away at it. Right.
There's just something I'm a little bit uncomfortable with our responses, though, and I don't know what the answer is to this. What if it's somebody who's repeatedly unprofessional, and it's an ongoing litigation, or you've got repeated transactions with that attorney? I mean, at some point you got to bring it up.
Well, I think that's an issue we deal with on the ethics committee,
right?
Because disciplinary committee, because we get cases that come to us of conduct that occurs in the courtroom, and I can tell you my initial reaction, I won't speak for the committee, is, why didn't you take care of that with the judge? Why are you bringing it to us? This should have been taken care of on the spot when the judge was an eyewitness to it. And I think, and I know we've got maybe one or more judges here, and I just want to say this at a risk of being rude, but I think sometimes what worries me...
With all due respect.
With all due respect. What worries me is sometimes when you get in a situation and the other person is abusing the court system, or abusing the motions system, or acting rudely, and you worry, is the judge getting this? Is the judge seeing this? Why is the judge not responding to this? Why is the judge not enforcing this in the courtroom? And I think that that's a fair and legitimate question, and I think that's something judges need to be aware of, is that we're looking for the judge to pick up the cue and step in so that we don't have to be idiots in trying to defend our client. And so I think that when it comes to calling someone out, sometimes instead of calling someone out, you're kind of hoping that when this is all occurring in view of the court, that the court is going to call them to task. And then you can sit down and look innocent for the next 10 minutes while the person's being chewed out. But to me, when I think about what are the hot button issues, what really kind of amps me up in a situation in the courtroom, it would be when this is occurring and I don't see the judge responding to it. And I think that if you've had that situation, you got to think about, whose responsibility is it when this occurs in court to be controlling the courtroom? It isn't yours. my 2 cents, with all due respect.
And it's not aimed at the judges here.
No, I don't know how many judges are here, but I'm just saying, I'm saying that for every court that I'm in, it always becomes a bit of a concern. And I think that we expect the judge to have our back on that, to enforce the rules that we play by. And what sticks in our craw is when we see someone flouting those rules.
And you got to think about the appearance that it has, even not just to the judge. I mean, the judge obviously is not going to. I mean, and we've been using some examples, and some of them are a little ancient, but there's current stuff happening all the time. This isn't a problem that is sort of passé. This is, I mean, I was in court, in the federal court, visiting federal judge, and the attorney had been told to go out in the hallway and to kind of solve, and they're not here, so none of you have to be concerned. I looked around before I used this example. So the bottom line is that the judge said, I want you guys to go out into the hall and to resolve the scheduling dispute. It was about depositions. It was just about scheduling depositions. And the one attorney returns. I'm already up there with my case, and the judge is talking to us, and we're dealing with it. He comes in and says, excuse me, Your Honor, the other attorney threatened to punch me in the nose out in the hallway. So how does that make them look? I mean, all they had to do was do a scheduling issue, and yet here comes in. So both of them didn't look good. I mean, the judge actually said, so what do you want me to do? How close was he? Were you really afraid that he was going to punch you? And so he was asking them whether they should file a criminal case for assault. So that kind of thing. So the point is, there are situations where the judge kind of feels, what the heck is this? And to supplement Rex's comment on that other case, I think also it is incumbent, even if the judge maybe hasn't seen it, then you should file that motion with the judge and say, rather than saying, okay, now, because we do run a fine line when we're considering some of these cases, and I think even as attorneys, reporting a person to the ethics committee, obviously that has its implications, right? You've got an ethical complaint filed against you and all that, but also, the issue is you could have brought this up with the court, and then a sanction could have been imposed there, and it avoids that ethical issue. And we don't want to be perceived, I'm talking about being perceived as opposing counsel, that we're using the ethical system as some sort of a sword against opposing counsel, and we're trying to just say, okay, I can't beat you on the law or the facts, but I'm going to swing the ethical sword at you to see if that'll dissuade you and make you settle or do whatever. So we are conscious of that on the committee, and we try to avoid those kinds of situations. So that's why when Rex comments about that, there's another factor there that's involved.
Speaking of ethical complaints, when is it appropriate to file a bar complaint against another attorney?
I don't know the answer to this, so I'll tell you what I perceive as being one appropriate time.
Well, that's advice you should follow.
I don't know the answer to this at all. But I do know that the rules do impose on us as attorneys sometimes when you are compelled or required to report behavior. It's when you know that there are violations of the rules. And that term, when you know, gives you a lot of leeway. Because when do you really know something for sure? This is why people hate attorneys, I realize, but when you know something has been done that is a violation of the rules is when you actually have an obligation to report. For me personally, you take this for what it's worth, I only find it to be something that I know enough to sort of warrant the time or be good enough reason to do it if clients are being harmed. If the public is being harmed by the actions of an attorney and you know it's a violation of the rules, I think that is when you have a clear obligation to try to protect them by filing a bar complaint. Outside of that, I think that it can be used highly inappropriately as a threat or as a moment of frustration because they were mean to you, because someone called me sweetheart. That's not the time to do it. But you do have an obligation sometimes, and that's when it's a clear yes for me.
Hear from the other junior member.
I only had 2 notes, and one was in order to protect the public. We've seen complaints where, attorneys say they're going to do something and then they don't, or they take their client's money and then they don't actually do anything for the client, and they continue to do that, or you see that they're going to continue to do that, and I think you have an obligation to report that attorney. And then, just like Jen said, the others, if you know there's a violation of the rules or even law, then you gotta report it. But even just to law enforcement, if it's something illegal. But beyond that, I wanted to give, I didn't want to give specific examples since we sit in the committee, and I just didn't want to disclose any specifics. But
We'll let you move on.
Okay, we'll move on. Question number 5. When is it appropriate to ask a court to sanction an opposing attorney or party?
Okay, I hate having to ask. This goes to what you brought up with the questions and what Rex already talked about. I hate having to ask. We shouldn't have to ask. If it's bad behavior and it's obvious, the court should be stepping up and doing it. So I don't know when it's appropriate, because I can tell you, if you're asking and they're not doing it on their own, the chances of you having those sanctions imposed are about 2%. So I hate having to ask. Whether it's appropriate or not, I don't know the answer to that, but you're rarely going to come out looking better on that issue, I think.
Yeah, that is the problem. And, you know, sometimes the client wants you to do it. And so that's a situation where you may not be able to talk your way out of that one. But I tell clients, you know, it's a low percentage thing. You're going to spend the money. I got to do the research. I got to, you know, you got to, if it's Rule 11, for example, you've got to send the safe harbor letter first, all that sort of stuff. And yet the client says, no, why don't you go ahead and do it? And I wouldn't do it if I didn't think I had a good reason for doing it, or that it was a grantable motion. Obviously, that's something you have to, you know, deal with on your own. But the point is, the advice is judges just don't want to do that. I don't know whether they don't want to decrease the business, you know, of having attorneys, you know, more look at the case more critically and say, hey, there's just not a case here. I shouldn't be filing this. Or, you know, they don't want to take that, because we do. What we said about ourselves is also what happens between us and judges, which is they see us every day and they deal with us every day. And so he may be sitting on the bench and he may be wearing a robe, but, you know, we're all participants in the judicial system, and so we deal with each other in a sense like co-workers. And so the point is, it's difficult to do that, you know. And so that is a difficult question to answer, and I guess everybody's going to have to come up with their own set of guidelines as to how much you think that thing will be productive. And then, of course, you got to deal with that person. You know, now you've requested they be sanctioned, or you've requested Rule 11, and then the next time you're dealing with them with a case, you think it's going to be smooth sailing? Obviously not. So, you know, that's the situation.
I agree with those comments. I think that you really have to be careful with the sanctions game, because once you shoot that gun, you can expect the other side's going to pull it out. So, you know, it's kind of the old, if you live in glass houses, you shouldn't throw stones. So if you're going to play sanctions requests on the other side, what I've seen happen in long, protracted litigation is, within a year, the other side's going to seek sanctions on you. They're just waiting for you to screw up. And then suddenly you've got 2 levels of litigation going on. And I just don't think it's worthwhile. I think the one thing you need to be sensitive to is, we all try to read judges, and you need to read the judge and look for when the judge is looking for you to ask for sanctions. Because there are definitely times when judges want you to step forward and ask for sanctions because they're ready. But they might not initiate it on their own. So you have to be sensitive to that.
It's the court's responsibility to maintain decorum.
Yes.
That's just not our responsibility.
But so often we're in courts.
So the courts just look at its responsibility.
Agree.
If you do decide to file for sanctions, how much proof do you need before you do? How much proof, like, it's based on a single statement?
Just what I would offer from talking with the judges before, and it's not my job to defend them, but I think perhaps this answers the previous question, was that maybe you shouldn't go to sanctions right away. Chief Judge Mangalonia had said she would be very responsive to a motion to strike. And I think if you file 1 or 2 motions to strike, they get granted, that really tees it up and says, hey, I've stricken 2 or 3 pleadings that were belligerent or just irresponsible. Then it's much easier to pull the pin on the sanctions grenade when you have 1 or 2 motions to strike granted. Maybe you shouldn't file for sanctions right away, but maybe you should take some sort of intermediate step, which is a motion to strike. Maybe it's a motion to compel where you've thoughtfully documented your very polite responses to his or her very unpolite emails to you. I think it's an intermediate step, but then that really tees it up and makes it, I've never been a judge, but I would imagine it would make it much easier for the judge to grant sanctions. There's certainly, the other side's certainly been put on notice. And a judge, if a judge grants a motion to strike, he or she is probably less concerned about, is this sanctions order going to be shocking or out of the blue?
Yeah, I think when Mike is saying this, what's going through my mind is I'm thinking about drafting the motion, drafting the affidavits, drafting the memorandum of points and authorities, doing the legal research for it, and I'm thinking, okay, how many thousands of dollars is that going to cost my client? That's just the opening motion. Then I've got to do the reply. Then I got to prepare for oral argument. Then I got to appear at oral argument. Start chowing up what that bill is for this satellite litigation. Most of the time, it's not worth it.
But I think also David's question also kind of consider, that we have to take a dividing line and say, we're talking about between attorneys in pleadings or in, dealing with each other privately, and what's going on in court, in an open session in court. And I think his comment goes more to controlling the decorum of what's happening in court and having somebody railing against somebody else and, that sort of thing. That is up to the judge. I think that David's right. I mean, you don't want to, you shouldn't be having to stand up there and say, and one of my points is, when that happens, you should, the judge, I think you can accentuate that and go back to what Rex said, which is build your case in a sense. If he's railing at you and he's using a lot of voice, I think you tone your voice down. I think voice modulation is something that we all kind of respond to. And if your voice tone lowers as opposed to his raising, that creates a stark contrast between the 2 levels, number 1. And then number 2 is the corollary rule of that is, if he's being rude to you, like I said, you're being paid to take it a little bit. But if he's being rude to your client, then at least object. You know what I mean? Don't if he's saying stuff, either your client's on the witness stand and he's being belligerent or whatever, then object. I mean, that is your job. You're supposed to defend him, and I think any judge would understand that that's your role and should support you in that effort. But again, it is about building to that crescendo. In other words, if he's railed on you once and then you get all irate and tell the judge, oh come on, sanction him or whatever, it's a little premature and it looks a little peevish. But if you've got a history where either he's doing stuff in the pleadings or you've had 3 or 4 hearings and now this is the 3rd time it's happened, I think you're justified in saying something to the judge and making a motion to sanction. Yes,
Okay.
I'm sorry.
Matt Smith was really good at talking me and sometimes Jennifer off of that ledge where we want to respond and ask for sanction, Rule 11, whatever. He was really good at walking us back from that and just building on what you said. It is a situation where every one of us does something wrong from time to time. And maybe, under the strict reading of the rules, sometimes we do commit sanctionable actions, but I think that the proper time to ask for it is, as you say, when history has developed. Extreme example is a couple of years ago, there was a lawyer who was a defendant in a civil trial for a malpractice case. And he was coming into court every day for a month, and the judge was listening to all these nasty accusations against him. Meanwhile, he was also acting as an attorney in other cases. And there was a motions hearing, and he filed an out-of-time brief, and his excuse for that was, well, I was too busy in my own. And I said exactly that. I said, hey, the judge is listening to all this nasty stuff about him. He's coming in here. He has filed this out-of-time brief, and that's a violation. and the judge did one of these, and she sanctioned it. So the history had built up in that particular case that I think the judge felt like, yeah, now's the time.
So advice is to build a record and everything will take care of itself from there. Okay, our next question, how do you maintain professionalism with a pro se litigant?
I don't think it should be different from dealing with a non-pro-se litigant, a client, or an opposing party with an attorney. It's the same. I mean, of course, you're going to encounter pro-se litigants who are not familiar with the rules, don't know the law, and things like that, or just are unprofessional. But I think you control your own behavior and you still act towards them with civility and with professionalism. And that was just my gut response to this question.
I think I agree. My gut response was it's the same, except maybe even you have an obligation to be more patient and let them to take more flack. And if the pro se litigant wants to be a jerk to you, it's okay. You're going to be okay. You're not an eggshell. Take it. So I think your obligation is to be even more of a punching bag if they want you to be even more patient, to be even kinder and more forgiving. Because at the end of the day, they're doing something that is incredibly difficult. They're in waters they don't know how to deal with unless it's a litigant that does it all the time, as some of the pro se litigants do. Besides those few examples, I think you just have an obligation to be extraordinarily kind and patient.
How does professionalism impact court-appointed representation?
I'll start.
Okay.
I have a lot of feelings on this, actually. Court-appointed representation in the Commonwealth is a bit unique because attorneys don't get paid timely. And that does affect the way some court-appointed attorneys represent their clients. I sat in chambers with a judge that basically explained to me that yes, you will not get paid for all the time that you work, and yes, you will get paid an extremely lower rate than you can keep your lights on with, but you have an obligation to do it as if they were a very good paying client, even though most attorneys don't. And that is exactly what I was told. So, how does it impact your court-appointed representation? It shouldn't at all. You have to do just as many hours, you have to work just as hard, and it doesn't matter that you're not going to get fairly paid or timely paid.
Oh, we can't add anything to that.
Thank you, Jen. Next question is, how do you exhibit professionalism in front of clients?
I think that comes most often when you're talking the clients down from the ledge. I mean, I think we've all had the experience of clients who have been put through the ringer and it's unfairly, you often think, and you really empathize with them. You see it tear apart their family. You see it affect their finances. Maybe they end up having to see doctors because of medical or emotional problems that come out of it. And you really can relate to them, but they just build up this anger and they really want to go and attack the other side. And that's where your skill as a people person comes in. As a lawyer, you've got to be a counselor, and you've got to help them with their problems and help with their view of the case and convince them that this is not the most effective, I've used the word before, pragmatic. This is not the most pragmatic way of getting to where you want to be in this case. I usually defend people, so it's usually not the way to get them defended successfully. And so professionalism, I think, is a really great opportunity, is in handling your clients, is in teaching them to be civil, teaching them to be professional. A lot of times I don't bring clients to court because A, I don't want it to wind me up perhaps for an argument, and or B, because I'm not sure how they're going to respond to what they're going to hear coming out of the other counsel's mouth. And so you've got to make the decision at times that maybe this isn't really a hearing they ought to go to. You know, you've got to think about that. Obviously, a trial's a different situation. But if it's a trial, I spend many, many, many hours counseling them about how they're going to act in the courtroom and how they're going to act around judges, how they're going to act out in the corridor and in the restrooms, cover everything with them. Because you do want to teach them about how to be civil and that they're on show at all times and that, that they have all the justification in the world to feel the way they feel. Their feelings are not, they're not right, they're not wrong, they are what they are, they're legitimate, but they can't let them control their decision making. That's why I'm hired as a professional, is to come in and to help them make good decisions under fire.
I think you see the situation a lot more in court-appointed family custody child support cases, and although those court appointments don't pay on time or pay a lot, there's actually a learning opportunity for young attorneys in those cases, because you learn to prepare your clients and educate them about how the process works. And understandably, in these kinds of cases, there's a lot of emotions, a lot of anger towards the other side, and there's a lot of trash talking. And so it's a lot of maintaining your patience, learning to listen to your client, distilling what they're telling you to what result they're wanting to get out of it, and then communicating that back to them in a way that they understand. And then effectively telling them, how are we going to get the judge to see that, or how are we going to get the other side to see it? So it's a lot of opportunity to learn how to deal with difficult clients, or I guess not difficult clients, but just as a practice, I think, for these types of court appointments. And it's going to be a very difficult situation, because even as a human being, and you see the situation where there's children involved, or families involved, it can be emotionally draining. But I see them as an opportunity to really, just like what Rex was saying, it's a lot of taking the time to prepare your client, educate them about the process, so there's no surprises. I've walked into a courtroom, and maybe it was my mistake, I'd forgotten to tell my client, hey, I might be really friendly to the other attorney, and we might start chatting about children or other personal things, and my client will say afterwards, hey, I didn't feel like you were advocating for me. And that brings me back to, well, I should have probably told my client ahead of time that, that person I've worked with in other matters opposite, but it doesn't mean that we don't have a friendly relationship. And so it's just a lot of that sort of skill set that you develop that you don't get to develop with sophisticated, educated business clients that you get to do in these court appointments.
But the civility issue, I think one of the things that's really kind of destructive in that regard when you're dealing with your clients or with your other general members of the public is, like I said, I want to give concrete examples, and that is talking bad about opposing counsel. So, I don't care if you think that he's the dumbest thing since wood. I think that you owe that respect to him as a fellow attorney. And I think those things are, tit for tat or reciprocal, just like the filing of the sanctions motion and all that. I mean, if you start talking bad about opposing counsel, one thing you heard even from the judges, this is a small community and it all gets around, it eventually gets around and it'll get back to you. And so, telling the client, and because the client is your client now, but eventually he's not going to be your client, he's going to be a member of the general public, and he's going to go to a barbecue or have a beer with his buddies or his family, and he's going to repeat what you told him. Oh, don't go to that lawyer because my lawyer says he's an ass, or he's dumb. And so those kind of things, I don't think that if you're a smart lawyer, if you're a good lawyer, that should show based on how you handle your client's case, not for you to have to say that or to belittle the opposing counsel in order to get over, so to speak. So I think that goes a lot towards establishing you as a civil person, as a civil attorney.
Thank you. Next slide, please. When, if ever, is it appropriate to threaten to report an opposing party's actions to law enforcement? And then, for example, you represent plaintiff in a civil action and you believe that defendant has perjured him or herself during a deposition.
tough question, and I'm just going to ask another question and then make the elders answer it. I'll add to that, when is it actually prohibited to threaten criminal action in a civil matter? Elders?
Well, no, you can't do that. I mean, you can't threaten. So you use the hypothetical a little bit. If you want to report something, you report something. But if you threaten the other side that you're going to report it, becomes extortion. So you don't want to go that route. The question, I think the question is, it's just like the question about privilege. When can you breach the privilege between you and your client? I think the issue is if there's some imminent harm to the public, to some other person that you know about, and you're, as Jennifer earlier said, so you're sure that this is going to happen, then obviously, not just because you're a lawyer, but because you're an average law-abiding citizen, you have to report something to law enforcement. I mean, that's the situation. Now, it's not usually that simple. It's not that easy. Sometimes, what if it's confidential information that you acquired as a result of, speaking to someone, maybe it's your client, and he tells you something that somebody else is doing, and if you reveal that information, it kind of does something to your client's case. So it gets very complex. It's too easy to simplify the facts and put it in this form of the question. But I think the guiding principle is the same as in, like I said, the disclosure of privileged information. You got to be fairly certain that there's going to be some potential harm to some other person, and then you got to say, well, I got to do what I got to do.
Can I ask another question to the elders?
I'm going to let you take the next one.
Elder number 2. In settlement negotiations, in a civil matter, your client is the harmed party, and they've been, there's been some conversion or theft, and as part of the settlement process, your client forgoes its right to report to the police that they've had something stolen from them in exchange for this settlement. Is that always inappropriate? I think that answer is no. So when is it appropriate to have those kinds of discussions? Rex?
Go ahead. Well, so the hypothetical is that you're in a settlement discussion, that part of the conduct that was involved is criminal, and part of what your client, my client, is giving up is that he or she is not going to report that criminal conduct. I think it's appropriate. You have the ability to decide whether you're going to report something. You can't misrepresent it and say, I'm not going to, it won't be prosecuted, because obviously that decision isn't within your control. You can't say that I'm not going to testify, because that decision is not within your control, right? You can only make a promise you can follow through with. But if it's that I'm not going to report, I think you can make that part of the consideration, and I've seen it happen. This hypothetical, I've never threatened or actually reported someone to law enforcement in a case in 30-some years. I mean, especially, it's a ridiculous question, because especially in, well, I mean...
Wasn't my question, okay?
No. But I mean, perjury...
I'm just the moderator.
Perjury happens all the time. I mean, get real. Perjury happens all the time that people testify falsely. But for as many times as perjury occurs in depositions or on the witness stand, how often have you ever seen it prosecuted? Very seldom, and any prosecutor knows that prosecuting perjury successfully is one of the most difficult things. Perjury and arson have always been the really tough ones to prove. So, I'm going to tell law enforcement that there's perjury. I mean, the AG's office is going to look at it. Somebody's going to kick it. It's not going to go through. So I think it's something I would never do. Vince, just
a comment, but just to add on that, on a practical level, once it becomes criminal, then we have, the whole purpose of depo is to try to get them to impeach themselves. But once it goes to the criminal level, then you have your opponent who's going to be able to invoke the fifth, and then you've lost your client's chance to go and finish whatever they need to do on the civil side, because then it has to take a back seat to the criminal side. So choosing to go and and reporting, a criminal act might actually be disadvantageous to your client because then you're going to end up taking that back seat.
Yeah, you're absolutely right. I did a case a few years back on two different tracks, the civil and the criminal side at the same time, and it messed up the civil case so much that you basically end up putting a stay on the civil proceedings until the criminal get done. So it is not a litigation advantage for it to switch over into criminal mode. It's actually a disadvantage.
Yeah, we actually had a case together where we were representing two different plaintiffs, and the defendant came in with a lawyer, and he admitted at the deposition that he hadn't filed taxes for 12 years. And so here we are, the plaintiff's attorneys, we're trying to get him to settle and pay us a certain amount. And so do we report him to the tax authorities and say, hey, he's guilty of tax evasion? And then he goes to jail, or the tax people take it. So this gives you a real concrete example of how you can be put on the horns of a dilemma when you're dealing with this criminal issue. I see by the sign that we're really...
Well, yeah, we have about 5 minutes left and a couple more questions.
A little bit less, but it's okay.
Okay. Our next question is our Godfather's question. Does professionalism extend outside of work hours? And is it important for attorneys to maintain a professional demeanor in public?
The short answer is of course. Of course it is, yeah.
I fell off my motorcycle once about 4 years ago. This lady pulled out in front of me and caused me to wreck my motorcycle, and I was hurt. But my response was to get up off the ground, take my helmet off, slam it on the ground, and then go over and start yelling at this lady. Ray Moffness, who was the DOC commissioner at the time, was a witness, and he agreed that it was not my fault. But when I went to DOC the next few days later to meet with the client, he said, "You're a lawyer, don't act like that," and it really took me to task for doing that in public. So it's kind of stupid.
Yeah, I think they covered that earlier when they said that, it's a small community and everybody, even if you don't know people, I've had people say, I don't know, and I don't know who they are, but, that's the point. The point is they don't know them, and they're going to judge you, based on what you do, because, I've had situations where I'm crossing the lane from one lane to the other. Oh, did that guy see me change without putting on my turn signal? That's how bad it gets sometimes when you're thinking about that issue. So
and I know what car you drive to.
Yeah, there you go. So.
And I don't think it's just it's a small community, because there's plenty of small communities in the States, right, where that isn't the situation. It's that there's something about the culture where there's an expectation that attorneys will act at a certain level of conduct. And
Well,
that
there is that.
doesn't necessarily apply in California, for example. Huh?
So there is an expectation that lawyers will act at a certain level of conduct.
Yeah, the expectation in California is a very low level of conduct. But the expectation on island is usually a much higher one.
All right, thank you.
Okay, so I'm going to
Next.
take on, I think we
Are you
can't
taking
cover
on the next question?
No, I'm going to pick on something that I think we should talk about as how do we promote civility. So I think we need to promote civility in a way that we deal with each other on a daily basis. And I think some things, they might be small things, but I think, for example, if you get a call from an attorney, if possible, you should try to return that call within the same day. I think that promotes a certain amount of civility that you said, hey, you're a colleague, and I respect the fact that you called me, and I need to at least within a day return that call to you. The other thing is the same thing with emails or letters. I mean, you should expect that person to send you an email, a short email, even if you can't respond to the substantive issues, to say, I got your emails, I'm kind of busy, I'll get a response to you in 5 days, or 4 days, or 3 days, whatever it is. And of course, the other thing is honesty. Like you said, almost Elvin, we've been around a long time. He and I sometimes get together and we talk about realm of the coin is the expression that we use. And that is, we talk about the fact that you build up a certain reputation based on that realm of the coin, whether it be with the judge or whether it be with opposing counsel. And if you're not honest with your opposing counsel and you tell them, oh yeah, we're going to settle that case next week, and then all of a sudden you file a new motion to try and litigate the case, well, what's he going to do? It looked like, you tried to sandbag him and file that motion when he's laying in the bush, laying in the bushes for him and attacking him when he didn't expect it. So I think that is something, again, we brought up the small bar, and you're dealing with people over and over again. So it is in LA and it is in New York, and you've got to keep that in mind. The other thing is kind of a small thing, but sometimes it helps to schedule your meetings with opposing counsel in the morning. We're all kind of human, and to varying degrees, we kind of, run out of gas or steam by the afternoon. And you've also had all the pressures of the day build up on you, whether it be dealing with a difficult client or doing something else. So if you have your meeting late in the afternoon, you've already got all that pressure built up, and now you're adding that to this, to have to deal with a tough lawyer that you already know is something that. So those are kind of small things, but believe me, when you put them into practice, I think the other side also gets that from you, and they'll hopefully reciprocate.
Thank you. Do we have any questions from the audience? Any last things you want to talk about? No? None? Okay, well, I want to thank our panelists and thank our sponsors, the Commonwealth Judiciary and the CNMI Bar, for this event. Thank you.
Thank you. Let's give them a round of applause. Before closing, I'd like to point out, those of you, we get CLE for this, for sitting here for this long. So any of you who have not signed in on the sign-up sheet, please do so. There also have been handouts that have been passed out earlier. If any of you want copies of that and weren't able to get a hard copy, email me. I will get them to you electronically. Probably not hard copy, but electronically for sure. At this time, I want to present the Certificate of Appreciation to the attorney. Why were you here? Or why were you chosen? Because you're the chosen one, okay? But thank you so much for sharing your observations, the answers to the various some of the off-the-wall questions. I didn't do it. Blame it on Ned. He was in Fiji, scuba diving. But thank you, Barbara, for being our moderator. And I have them in order. Thank you. I remember you a while back. Thank you, Kathy. Judge Bellis. And Jen, always a worthy friend. For closing, I'd like to call the Honorable David Wiseman. He's doing his victory lap for the last week of May, so to speak. So he's going to do our closing.
Thank you, Lillian, and members of the CNMI Bar. It is indeed my pleasure to be here to offer some closing thoughts. I won't be making many public addresses anymore. Outside of next week at my retirement ceremony, which I hope you all got an invitation to. It's a public event. In any way, reflecting back on my 39 years in the CNMI, originally, I recall being a charter member of the non-integrated bar that we started around 1980, 1981, somewhere around there. I don't see any other charter members here at the time. Mike White was in there, a couple others. Ben, I think you may have been there. In any event, part of the 39 years I was in practice for 19 years in private practice here. 15 years as associate judge, and as you heard, 5 years as special judge. That was from 1995, along with Special Judge Kosak, who was there, Special Judge Bellis was also there. I've seen many members of the bar over those years do their best to maintain the professionalism and decorum when they would routinely come before me. All practicing attorneys, and this may be a little bit repetitive in my earlier statements, but in more format, should be aware that preamble to the CNMI Rules of Attorney Discipline Procedure. And I'd just like to read them. It says, in relevant part, that the license to practice law in the Commonwealth is a continuing proclamation by the Supreme Court that the holder is fit to be entrusted with professional and judicial matters and to aid in the administration of justice as an attorney. It further provides that it's a duty of any recipient of that conditional privilege to practice law, to always act, both professionally and personally, in conformity with the standards imposed upon members of the CNMI bar. These rules remind us that lawyers and judges are part of a highly regarded elite class of professionals who swear an oath to use those specialized set of skills for the social good. We're trusted by the average person to license only those who are fit to practice before the courts and trusted to discipline our own members. So when we abide by these rules, we don't only do so because they can't find us, but because we are beholden to an implicit promise to meet the expectations of a community that trusts us and respects us. Professionalism is a call for a common sense of mission, dedication to civility, and service for the common good. On the issue of service, I've made mention in the past that the very core of any civilized society is dependent on the indispensable existence and adherence to the rule of law. The belief in the rule of law for an orderly society demands a commitment to support it. Lawyers play a very important role in such commitment because they are considered to be the champions of reasoned debate and are indispensable to the preservation and implementation of the rule of law. However, a key factor in order for lawyers to have a positive effect in this role is that of professionalism. The public confidence in the integrity of our courts is also dependent, among other things, the professionalism of the lawyers practicing before it. Lawyers have an obligation to engage in dignified conduct when conducting their profession. Lawyers have always had a most significant and historic role in the development of the nation and the governments of the United States, both as servants of the public in the administration of justice and as agents of the democratic forms of government we have. Indeed, 31 of the 55 delegates who met in Philadelphia over 200 years ago were lawyers. In closing, I submit to you that these principles espoused today and in my statements hold no more truer than in any other jurisdiction but in ours. As lawyers of the CNMI bar, we should be mindful of the fact that we are relatively young but strongly developing jurisdiction. Our government, think about it, is only less than 40 years old. 40 years old. In the integrated bar that we have, non-integrated, integrated, not terms that are used commonly, but the non-integrated is without the court's involvement. So we voluntarily, there's several others, Mike White was one of them, and Jesse Joe Delpy. We got together, several others, and Doug Cushing was there. I think Ted Mitchell may have been there. And we got together and decided to start forming a bar, and eventually the court got established and integrated the bar. In any event, that integrated bar that we have, that you're all members of, we want to be members to practice law, is only about 35, 36 years old. For those of us in the judiciary, this new and developing jurisdiction provides us with what has been and continues to be a great opportunity to shape our court with policies that seek high standards of professionalism and ethics from those practicing before us, and to define our service to a community that trusts us to do what's best and to do what's right, not only for the clients, but to uphold our continued promise that is the rule of law in the CNMI. I wish you all the best in your endeavors. Thank you.